Justice the appellate division for the department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near if their attendance shall be heard.
Thank you. Please be seated. First case on for argument today is 277 People versus Johnson. Counsel, can you hear us? We can't hear you. You might be muted.
I apologize for that. Can you hear me now?
No apologies needed. Things happen. I can hear you fine. Please proceed.
Thank you. My name is Kellyanne Argy, and I'm here on behalf of the defendant, Jeffrey Johnson, today. And we would like to argue the question of whether or not when Mr. Johnson was resentenced, immediately following his sentencing, his actual sentencing, whether or not it was a clerical error that the court was correcting in resentencing him, or whether or not Mr. Johnson was actually uninformed about what was going on when he was called back in to be resentenced. And there are multiple reasons for that, because the record is not clear. There is no detail as to why Mr. Johnson is being resentenced by the trial court. The trial court simply says—
Let me interrupt you, okay? So the plea agreement called for the sentence to be 1.5 to 3. Is that right?
the plea agreement did call for 1.5 to 3. That is correct.
Okay, and then the court misstated, the plea agreement in the first instance on the day of sentencing.
In the first instance on the day of sentencing, yes. So I will say that the court said at sentencing 1.25
to 3.
excuse me, 1.5 to 3rd. She uses different terms, 1.5 to 3rd, and then sentences him to 1.25 to 3.
Right, but in the end, she realizes her mistake and before the end of that day, resentences him to what the plea agreement actually was.
Correct.
Okay.
However, what we would like to argue is that the trial court during the entire plea agreement used those words interchangeably and also stated to Mr. Johnson on more than one occasion that she hadn't determined what the sentence would be. She did inform him on what the maximum sentence could be, but there was no indication on whether or not she could reduce the sentence and go with minimum. And there is no minimum presented to Mr. Johnson. Whatever it may be is basically what she says during.
So let me ask you this question. I think probably the most important question. Is this error preserved for our review?
We believe it is, yes, Your Honor, as argued in our papers, that there was no need for it because it was not a voluntary, knowing, and intelligent plea.
Okay, so that is normally preserved by a motion to vacate. And I don't see that that was the situation here.
I would rely on points 2 and 3 with respect to preservation, which I would have to refer to my paper because I really didn't focus on that preservation.
You're relying our interests of justice jurisdiction to get there. Is that right?
Yes, Your Honor. Yes, definitely.
All right. I think we.
Anything further, counsel?
I would just like to point the court's direction to also that when he was resentenced, Mr. Johnson, obviously there were some issues going on. He didn't want to come back in, but he states on the record that he was wanting to just speak to his lawyer. And the trial court, there's no indication on the record whether or not the trial court allowed him to do so. And in fact, we find some aggressive statements by the trial court along with the defendant, but we really don't expect that kind of thing from the trial court. I think that it's very clear the lack of communication, the lack of detail, the lack of information being given to Mr. Johnson at that resentencing without him being able to speak to his lawyer is clearly showing that he was uninformed.
Thank you, counsel.
Thank you, Your Honors.
Case 278, People versus Winsett.
Good morning, Your Honors. Sean Hennessy for the appellant, Mr. Jonathan Whitsett. I'm going to focus on 3 points in oral argument. My first being weight and sufficiency, the second being misconduct, the third being the defective grand jury proceeding due to prosecutorial misconduct. As far as point 1 goes, Mr. Whitsett challenges both the weight and the legal sufficiency of this conviction. As Your Honors have read, there was.
This is a circumstantial case.
I mean,
There's no witnesses to the shooting, right? There's no forensics relative to gunpowder on the hand of the defendant.
That's correct.
There's no fingerprint evidence that is damaging. We have a situation, according to your argument, we have a situation where the officers had no one else to point to, so they pointed to him.
That's exactly right, Your Honor. They actually did have someone else they could point to, though, and that was Mr. Ward, but he was never investigated.
Right. Had they investigated him, they would have found out that he had a previous conviction, which the detective that was investigating this case, when he learned of that, kind of said, not a big deal.
Yes, Your Honor.
Right.
And I'm not saying that Mr. Ward was the shooter. I'm just saying that he offers another alternative to Mr. Whitsett and something that, you know, the people should have looked into, the police should have looked into, but did not.
And part of your argument today is, and I don't want to get you off your points, because
Sure.
you're limiting your argument to the 3 points, and we appreciate that. But really, there's your argument is those points have to be looked at together. And the fact of the matter is, your argument, I think I understand it, is you've got, when you have a case like this in circumstantial evidence, and you've got prosecutorial misconduct, as you allege there was, right? And you have testimony of witnesses that's coming out that shouldn't be in, that maybe if there's one instance, it's okay. Maybe if there's 2 instances, it's okay. But the compilation of the problems in this case, coupled with the fact that it's a circumstantial case, you think the 2 may have bled into each other, causing the jury to come to the verdict it came to.
Of course, Your Honor. The misconduct was pervasive from the beginning to the end. And again, yes, you are correct. This was a very, very limited case as far as the evidence goes. And as you know, as you know, the evidence decreases, the lack of prejudice from misconduct increases. And I would, you know, I don't want to deal in speculation here, but even if this was a strong case, the amount of misconduct in this was unreal. I mean, from the beginning to the end. I mean, just you know, at one point, the prosecutor questioned my client on cross-examination, asking him, "You're testifying because you want to influence the jury."
The judge issued a curative instruction on that. What's your take on
There was no curative instruction. I mean, he said something. The judge said something, but
that? He had the right to testify. Yeah.
but-
And everyone has the right to.
yeah.
That was his.
That was it, though, Your Honor. I mean, there needed to be more than just hand waving, saying everybody's got the right to testify. I mean, you know, he had to assure the jury and assure the fact that this trial was not going to be defective by telling them this is a constitutional right. This is something that everybody has the right to do, to testify in their own defense. And for the prosecution to just denigrate that and say, well, if you're trying to influence the jury in the context of everything else.
So based on what Justice Whalen was saying, is it your opinion that in and of itself is enough to reverse the conviction, or is it the totality of the other prosecutorial misconduct that you're going to be referring to?
I would say that the pervasiveness led to a pattern of misconduct, and I think the court should look at, I think that's the easiest way for reversal for the court to look at, is just the pervasiveness and pattern of the misconduct. But if I were to pick one where it was the killing shot, it would be that. He destroyed any constitutionality that my client had in testifying.
Let me ask you this. And you know the record obviously much better than I do. But one of the difficulties, I'm wondering if you have an answer to this. One of the difficulties, I think, in this case is you have the victim who has a gunshot wound in the passenger side of the car. I think the only testimony was the forensic testimony about the point of entry being, I think, the top right side of the forehead
That's correct.
on a downward trajectory,
That's correct.
right?
Yes.
And there was some testimony about the proximity of the shot, where it was when it was being taken. But assuming for the sake of argument that the prevailing evidence is that it was not a gun pressed to the head, and it was not a gunshot that was very close to the head. It had to be some distance away. When the defendant arrived back to the car from the liquor store, the second liquor store, and saw the victim, what he thought was asleep. I think that's if I have the facts, you'll correct me if I
That's
get
correct.
wrong. And drove off without attempting to wake him up. The window was up in the car. There was no shattered window. There was no, and I can only picture somebody standing outside the vehicle and the gunshot coming through. And so if the window's up, does the shot have to take place inside the vehicle?
It does, unless someone shot him and rolled the window back up, which doesn't seem likely. But if it took place, it would have to have taken place on the driver's side of the vehicle, and the trajectory of the bullet, it doesn't make sense. I mean, I guess conceivably it could hit a downward if his head was turned, but even then, it doesn't seem
There's
likely.
no indication of a ricochet inside the
No.
inside the vehicle. I guess there's the victim could have possibly turned completely to the left
Yes.
to expose that part of his head. But I'm confused and I'm troubled by how does this happen? But this gets back to my initial comments that your argument is, yes, it's difficult to explain how this happened. But because they can't explain how this happened, doesn't mean that the defendant did it by default.
That's 100% correct, Your Honor. There's inferences and there's evidence. I mean, there's an inference of suspicion. Sure. I mean, Mr. Cobb was found in Mr. Whitseth's vehicle.
Mhm.
There's a couple things that point to suspicion, but suspicion is not proof. And there is no proof here at all. I mean, there is no, I mean, as we've already talked about, I mean, there's no forensic testimony, there's no forensic evidence, there's no witnesses, there's no surveillance footage.
There's no
nothing.
history of the defendant ever operating a gun.
No, I don't think he knew how to. From the record, he testified. He's never held a gun in his life. So in order to hold that gun and to go with the theory of how Mr. Cobb was shot, he'd have to be a heck of a marksman from that angle shooting him, so.
From some distance.
Yes, yeah, because I mean, they eliminated point blank, they eliminated a short shot. It had to be medium or long, and I think she categorized medium or longer as 10 feet or longer, something like that. I might be misstating the record, I might be wrong in that, but I think that's what she said.
Why don't you get to, because we got a busy calendar today.
Sure.
Why don't you get to the grand jury issue for us, because you did want to touch upon that.
I did, Your Honor. Would you expect an innocent person to tell you that? That was a question that was asked by the prosecutor. Do innocent people give false statements? No. Prosecutor doubles down on that. Who does? Police officer, guilty ones. He engaged in it, excuse me, and when he didn't engage with it, he stood by idly and let it happen. I mean, and as the prosecutor and the grand jury has a duty to justice and instruct the jury on what is proper and what is not.
How many pages is the grand jury testimony?
It's 120, and there were six pages of
It's
this.
161.
Okay, 161. I mean,
6 pages of this, right?
the last 6 pages, Your Honor.
And there's 12 witnesses.
Last 6 pages, though. That was the last thing they heard.
There's 12 witnesses.
I agree with you, Your Honor, but this was broken up over a series of days.
So it's 2 days, right? But isn't it, what's the overall pattern of bias? The last 6 pages?
Yeah, the last 6
Hundred and
pages.
61 pages, you're saying 6 pages is the overall bias?
It's not arithmetic, Your Honor. It's when it took place. It was the last witness. It was the last thing the grand jury heard before they were instructed. You can't unring that bell. I mean, if it was the first witness, I would agree with you and say, well, maybe we don't have much of a case here. But it was the last things that the grand jury heard before they voted. And I think that has to count for something other than just 6
Well,
pages.
And part of your argument, I think, if I understand the grand jury, is that once this was done, there's an opportunity for the prosecutor to fix this by charging the grand jury,
Of course.
by explaining to the grand jury what their duty is, what their responsibility is, what they should listen to, what they shouldn't listen to, what was wrongly put before them, what wasn't.
Yes.
And part of your argument is that didn't happen.
It didn't happen. And part of my argument too is it should have happened as it happened. And he should have stopped the police officer and gave a curative to the grand jury at that point. He did not. In fact, he suborned it. I mean, he asked for it. He engaged in it. I mean, at one point, I think it was Detective Constantino characterized the right to silence and the right to counsel as obstruction of justice. How do you get around that, Your Honor? I mean, even if it is the last 6 pages, again, it's the last thing that the grand jury heard. And for them to hear that, well, you know what, if you ask for a lawyer, you remain silent, you must be guilty and you're obstructing the police officer. Without instruction, without more, that's what they voted on. It's one piece of the puzzle in an intricate tapestry of misconduct that began at the grand jury and ended at closing argument.
But for that testimony, those last 6 pages, the grand jury would not have indicted?
I don't think they would have. I think that the evidence was the same evidence as the trial evidence. It was still scant. It was still speculative. It was still circumstantial. There's no reason to believe they would have if they didn't hear that. If the police and the prosecutor didn't denigrate my client and his constitutional rights, there's a chance. And that's all there is. That's all there is necessary is if there's a chance that they would have voted differently.
Just to follow up on Justice Montour's question, wasn't there 10 other witnesses that testified?
There was, Your Honor. But again, I would state that this was the last thing the grand jury heard was this witness, this testimony. With 12 witnesses and 160 pages, I'm sure a lot of it was forgotten. But that was the last bell they heard rung before they were charged and they voted. So I would say that again, we don't look at arithmetic. We don't look at the amount. We look at pervasiveness.
Willful and pervasive.
Yes.
And it was 12 witnesses and 10 testified before those last 2.
One comment, though, Your Honor, could be willful and pervasive. One comment. And this was more than one comment. And again, it's not how many witnesses and how many instances there were. It was the effect of it and how damaging it was.
One of your arguments, I think, is in terms of willfulness, is that you have the prosecutor asking the leading question and drawing out the improper answers from the detective and the grand jury.
That is correct, Your Honor.
I mean, it's not, which we sometimes have, where you have lawyers trying cases or grand jury presentations where they ask innocent questions and the witness just kind of out of left field throws out a problem answer.
Sure.
And then that has to be fixed. But here, I think your argument is there was willful conduct here in that the prosecutor was intentionally eliciting this information. And the person that structured the witnesses and left this witness to the very end and left this questioning to the very end was the prosecutor, right?
That is correct, Your Honor. He pieced it together and he engaged in it. And again, when he didn't engage in it, he just stood there silently while he let, Detective Constantino talk about it. To me, that's willful and pervasive. It's not the amount of times it happened, it's how damaging it was.
Anything further, counsel?
No, unless the panel has any other questions.
Thank you.
Thank you.
May it please the court, Michael Hillary for the people. If I may, I'll begin with the last point first, the grand jury. Justice Montour, you pointed out correctly on this record that we had 161-page transcript. There were 12 witnesses, as Judge Hanna, you pointed out. Typically, when we're looking at grand jury proceedings and we're deciding whether or not they were problematic and they should result in dismissal, we look to see if There is pervasive misconduct and typically willful misconduct. I don't think we get there on this record. 6 pages of suspect questions, 6 pages out of a 161-page transcript. A prosecutor might go into the grand jury and he might just have a bad day. And the reality is when a prosecutor has a bad day at the grand jury and makes some mistakes, he doesn't have the benefit of a judge and he doesn't have the benefit of a defense counsel raising objections to correct the situation. He is there himself as judge and counsel. Maybe the prosecutor had a bad day, but this was not willful and it was not pervasive. And I think the record attests to that fact. Moving on to this, I'm sorry, I thought Your Honor had a question.
No, I was just looking at some of the testimony from the other witnesses as far as being, the compilation videos and certain things that happen and throughout, it appears as though, the grand jury members could have, obviously recalled all that information and possibly put aside the comments by Constantino with respect to these other various items. Because it appears as though there's a significant amount of evidence here that the grand jury could have considered to indict.
I believe that's correct, Your Honor. And of course, there is a lesser standard of proof at the grand jury than the trial. The trial jury convicted. It was proof beyond a reasonable doubt. And here they had reasonable cause to believe that the defendant committed the crime. So much the same evidence, that's correct. And I think with a lower standard, there's no issue here.
Counsel, just so I'm clear about your argument, is your argument that the very end of the grand jury proceeding when the questioning is being elicited from Detective Constantino, I believe it's Detective Constantino.
Yes.
Yeah. When that questioning and answer takes place towards the very end of the presentation, before the grand jury is about to either return a true bill or a no bill, right?
Yes.
And there's no charge to correct the problem. But before we get to that, do you agree that there's a problem with the question and the answering that's taking place just before the grand jury begins to deliberate on this?
I definitely think the prosecutor would like those questions back. Yes, I think that was a problem. My only maybe disagreement with counsel here is that when a grand jury presentment results in dismissal, it is under case law because they cannot be relied upon. Those proceedings can simply not be relied upon for a reasonable result. And it looks to misconduct being pervasive and willful, an overall pattern of bias here. And I just don't think we get there, Your Honor, with 6 pages of last.
So if, and I'm not saying this happened, I want to be very clear about that. But if this grand jury presentation was set up deliberately to arrange for all of the witnesses that came in the order they came in, and Detective Constantino was positioned at the very end intentionally with the questioning, which was being asked of him, and the answers drawn out. If that was the design of the presentation of the grand jury, written down, structured, would you say that that was willful and pervasive?
If the prosecutor intended to elicit those or ask those questions, improper questions, and set it up that way, then I think you certainly have a willful attempt there or intention by the prosecutor
Does
to.
that pervade the entire presentation? Because it was set up in a way that was designed in a way in a case where a prosecutor knows that this is a circumstantial case anyway. They have no witnesses. They have no DNA. They went and searched the cameras in the community to see what they could find. They've got nothing, right? They've got no gunpowder residue on the defendant's hands. So if this was set up in such a way, and I'm not saying it was, but I want to know what your answer is to this. Isn't that pervasive? Doesn't that pervade the entire presentation? When we talk about pervasive, we're not talking about, well, if everything was fine up until the last 6 pages, then it's fine. Pervasive is, does what happened infect the entire presentation?
I agree with Your Honor. And I think my statements to the court on the issue imply that such a design did not exist. I don't think this was a nefarious presentation. I don't think the prosecutor woke up and said, I'm going to orchestrate this. I'm going to arrange it so that the concluding remarks are going to be improper and it's going to taint the jury. I just don't believe that for a second. I don't think there's any evidence of that.
I want to go back to your statement that the prosecutor was having a bad day. And I think you could have a bad day with the wrong question slipped out of your mouth, not the way you wanted it, but this was a series of improper questions, one after the other. It seems to me quite a bit more than a bad day.
Well, Your Honor, there was, to be clear, in the record, there was a remark by Detective Costantino, which is one of the remarks that counsel is pointing out was improper to the grand jury, that was not elicited by the prosecutor. It was actually non-responsive to the question. Not all of what came out was directly elicited by the prosecutor. There were certain questions that were improper. For example, would you expect an innocent person to do that or say that? Or who typically makes false statements? I think it was a question to that effect. That was improper. There's no question about it. But I don't think, Your Honor, still that this is a highly circumstantial, it's an exclusively circumstantial case. And the grand jury is hearing speculation of a silent shooting, which is going to be almost impossible for the people in these circumstances to falsify. It doesn't matter what proof the people put on. If someone gets it in their head that this was a silent shooting, there really is no chance out of the gate for the people to prove their case. So now that doesn't justify asking improper questions, but I think we can maybe sympathize with the prosecutor here who believes that this defendant is guilty of a crime here and is trying to present the case in the best possible way. Maybe a little latitude is in order. I believe that it was a bad day for the prosecutor in the sense that he clearly, in retrospect, would not have asked those questions. He did. But I don't think the record as a whole, and I don't think the record proves differently, the record as a whole doesn't show that this was intentional by design, pervasive. It was an overall pattern of bias. I just don't see it.
Even so, it was, in the sense that you got 161 pages, you got 12 witnesses, Constantino's the last one. It has to be typically willful act on behalf of the prosecutor. Is this deemed to be, could it be considered to be an isolated incident, such as in the Houston case has indicated that isolated instances of misconduct do not invalidate the grand jury proceeding?
That's right, Your Honor. That's right. And I think that's really what happened here. I think the prosecutor would say that he had a bad day. Again, it doesn't justify intentional misconduct. I just don't think that's what's going on here.
That's not in the record about a bad day.
Right.
And
No, Judge, it's not.
And then we can say, well, how experienced is this prosecutor? Is he a rookie? Is he someone that, because if we knew if he was there 30 years, we say, well, it's probably not a bad day. It probably was intentional. And if he's a rookie, you probably say he's inexperienced. This bad day thing is kind of.
It's fair enough, Judge, but he's a colleague of mine, but it happens, Judge, that that you don't have the benefit. This is.
He's a colleague here. You don't have to tell me how experienced he is.
The prosecutor before the grand jury just doesn't have the benefit of the insulation offered by a defense attorney and a judge. And so when a prosecutor makes a mistake at the grand jury, it's magnified, right? There's no correction, there's no argument, there's nothing. It's just the prosecutor and it's a mistake. And it's very easy, maybe with a couple of mistakes, maybe several, to look at that prosecutor with some skepticism and say, what gives? And my only suggestion to this court is I think looking at the record as a whole, this prosecutor was not trying to tarnish the proceedings. It wasn't his object, however mistaken some of those questions were.
Your opponent might want to argue that at the end of the vote of the grand jury, it was the defendant that had the bad day here. But do you want to move on to the other argument?
Sure, Your Honor. I'll go to the sufficiency if that's what the court would like. Yes, this was a circumstantial case, but this defendant was alone with this victim the entire night. And there is no evidence that anybody else was in the defendant's black sedan but William Cobb. These two, for several hours, from the time they left the comedy club to the time they roll up to or near William Cobb's house, the defendant had opportunity. There is absolutely no evidence to suggest that anybody else committed this crime. None.
What about Mr. Ward? I mean, there was a
Ward- yes,
contention
Your Honor.
by your opponent indicating that all the police can investigate Ward.
The only thing about Ward is speculation. That the fact that they may have been involved in some kind of relationship and the fact that Ward may have known that the defendant, well, actually, he would have known according to the testimony because the William Cobb introduced defendant as his boyfriend, is speculation that somehow Ward now has it in for Cobb. That's it. It's
And
just,
where was Ward's opportunity? It seemed like the only time that they weren't together, Cobb and the defendant, was when the defendant was in the liquor store.
there's testimony that Ward lived about 20 minutes or so from Cobb's house, but there's no testimony that he actually ever showed up. And there's certainly no testimony that between the time they leave the comedy club to the time that they get to Cobb's house, that Ward has any interaction. He's not present. He's nowhere to be seen.
He's on the phone with
I think that's pretty clear, right? There's no testimony about any of that.
Right.
I think your opponent's argument might be, there was no investigation either. There was no effort to try and investigate Ward, to find out where he was, to get his cell phone information, to track down where that phone was moving, which we do all the time in these cases. Now that we have this technology, right? So there was no effort. So to say that there's no investigation and that he was dismissed as a potential suspect, and then say because there's no evidence, it's all speculation, seems to me to be, begging the argument.
Judge, I'd respectfully differ with Your Honor on the point that there was no investigation because Detective Costantino did question Ward. He did speak to Ward about it, and he concluded from that discussion that Ward was not
He
involved.
asked for Ward's phone.
I'm sorry.
He asked for Ward's phone and Ward
did.
said no.
That's true.
He
And
never did a background check on Ward to find out that he had a criminal conviction for, I think, some kind of assault with a weapon.
he did. He did have that. I think
He never even did that
several 10 years
research.
prior, I believe it was, but I'm not sure.
Had he done that initial step, might he have taken more of an investigative interest in Ward and
I think
attempted to get the cell phone records, attempted to do more, attempted to find out where he was, talk to the people that he was with to confirm his story?
all of these things could have happened, and we would all say at the end of it, that's fantastic, that's great. I don't think the fact that they didn't do all those things renders this investigation completely flawed and unreliable because you had other witnesses like Jessica Rivera, Cobb's friend. You had the testimony from the defendant himself. Ward is not around. He speaks about who was at this club, who was present. You had Cobb, you had Rivera, you had the defendant, you
He said
had
Ward is not around where?
anywhere at the comedy club. There's no testimony that Ward is present at the club
But that's
or when they leave.
That's my point. My point is there's no testimony as to where Ward was. So your argument is Ward wasn't anywhere. Ward wasn't there. We don't know that because there was no investigation into Ward. You're saying because there was no testimony about where Ward was, he wasn't there. You see the flaw in the argument?
I think Your Honor is saying I'm begging the question, and I understand Your Honor's point. I would just say that it's not without value that no witness ever points to Ward being there, right? So it's speculation to say that Ward may have been there if no witness is saying that he was there.
It's one of the problems, I think, with investigations where the investigator jumps to an early conclusion, comes to a resolution as to who they think did it. They're sold on it, and they close off all other avenues and don't go down those just to check them off to make sure due diligence was done. And in this case, had there been some steps, I think your opponent would argue, some steps, Ward would have been further investigated. And then we would know where Ward was. And maybe your argument is an investigation was done. Ward wasn't there. He was over here. And we know that because he had his phone and he was texting and the phone was bouncing off a cell tower, 50 miles away. We don't know.
And I want to, just for sake of argument, I want to adopt everything Your Honor just said, that this investigation was flawed, that it didn't go as far as it could have. But I'd like the court to consider, yes, it's a circumstantial case, but consider all of the circumstantial proof. Consider the defendant's own statements to Detective Stephanie, his 2 interviews, Consider, as Your Honor already pointed out, the fact that there is no bullet damage to the body of the car, none of the door panels, no bullet damage to the windows. Consider the fact that between 11:36 p.m. on June 18th and 11:38 p.m., defendant's vehicle comes to a stop. It's a 2-minute stop shortly before reaching Cobbs's house, where you would have had opportunity. Consider the fact that the defendant had no answers for anybody. From the time that he's speaking to Cobbs's mother on the phone, and she is saying, you were with him the whole night, what happened? You had to have seen something, and he just doesn't have anything. Consider the fact that his story changed when talking with Detective Stephanie. First, he didn't mention that there was any phone call between Cobb and Ward that happened in the defendant's presence in the car. In the second conversation, suddenly, Cobb is having a conversation with someone. He doesn't name who that person is, but someone. And we know from talking from the rest of the proof that, and from the messages that are on Cobb's phone, that there was some romantic dialogue going on between Cobb and Ward. And we know that there was trouble in this relationship between the defendant and Cobb. There was professions of love at one point, and then there was abuse going on at the other point. And we know on June 4th, Cobb said to the defendant, congratulations, you're single. Right. So defendant lied about the fact that there were problems, even abuse in his relationship with Cobb to the police. The defendant also admitted that Cobb was probably speaking after he returned from the second liquor store to get to that car and go to Cobb's house. So Cobb is still alive, according to the defendant, and what the defendant probably believes was going on. So now you've got the drive from the second liquor store to Cobb's house, and the 2-minute pause. And the defendant only discovers at the house that Cobb has a bullet hole in his head and can't explain this. It's maybe a negative proof case, but who else if not the defendant? I mean, who was with him the entire time? There was no evidence in this investigation that anybody but the defendant was with Cobb that entire night. So, unless the court has any other questions, I'll wrap.
Counsel, thank you for your argument.
Thank you very much.
You're going to call this one?
Okay, case number 279, the People versus the Quinn Gray. Morning, counsel.
Morning.
You can proceed.
May it please the court, Nicholas Tafonso for Dyquin Gray. I'll be addressing points 1, 2, and 3, but from the outset, I'd just like to note that these points are interrelated, and the prejudicial impact in each needs to be considered in the context of the whole, really. So the overarching argument here is that this was a weak case where the deficiencies in the proof were filled in with highly prejudicial and improper testimony and prosecutorial misconduct. Point 1 is that the verdict is against the weight of the evidence. The verdict hinged on the testimony of 2 witnesses who were problematic. They were both, for one, biased. Bell had an agreement with the prosecution and reduced his sentence from a life sentence down to between 5 and 10 years.
And the jury heard that, right?
The jury did hear that,
The
yes.
jury knew of it and they could assess whatever they wished to that testimony based on this deal.
Yes, the deal was not hidden from the jury. They were aware of that, but there were also, I mean, there was more than that, more problems with Bell's testimony than just that it has that inherent motive there. But the testimony itself, as I argued in my brief, manifestly appears tailored to distance himself from the event, from the crime itself. There's multiple things.
Well, first he denied any involvement, whether he was even there, correct? That's your reason, that's your main point for why the verdict's against the weight of the evidence.
Well, are you referring to his initial denial to the detective that he was there?
Yeah.
I don't think that's my main point. I think
It's a key point.
It's a key point, sure. I think there's just a number of his final story that he settled on at trial is not believable in several respects. One of them is that he says that the shooter was masked the entire time, and that he was picked up on the side of the road. He's masked on the side of the road, and then they drive around for something like 45 minutes to an hour, and then he's masked the entire time in the car. That doesn't seem likely, just to me. Then it was only on cross-examination where he's questioned about how he knew who the shooter was if he was masked the entire time, and then he volunteers that, oh yeah, Coleman, who's now deceased, called him by his nickname. But that was only on cross where he says this. Then there was the idea that he was selling rides, and that was the reason why the shooter was in his car in the first place, but they had never agreed on a price, right? So that doesn't make any sense. And then his story is further contradicted by the video evidence of the car, right? So the video compilation shows the car essentially acting as a getaway car, right? He's not just waiting for him to get back from the gas station. He's making a K-turn, the door is opening as the guy is running to the car, and the car is already taking off before the door is even closed, right? That's all on video, and it contradicts his stance here, and it supports what I'm saying, which is that he was testifying to distance himself to the furthest extent possible.
Well, what you're pointing out here, didn't defense counsel point that out at trial?
Yes.
So the jury was aware of these arguments.
Yes, the jury was not unaware of these arguments. Yes, right. There was another witness who also was biased. She has her. I mean, let's just summarize this as complicated and significant domestic resentments, say, and.
And
So you may
wait,
say, but I'm sorry. You may say bias, maybe this is someone that was along for a ride they didn't want to be on anymore, you know?
Oh, I'm talking about McGee Thomas. Are you?
No, you're saying the witness may be biased, but unless I'm confusing the facts, isn't this where someone was seen going into a liquor store? And then next, they kept watching and following the individual, and then he told the car to pull over here while he ran over to the guy at the gas station?
Well, I'm saying that the witness Bell and witness McGee Thomas were biased for different reasons. Bell is biased because he doesn't want to be.
No, but you're saying biased. I'm just trying to keep an open mind.
Sure.
But it could be three people in a car and something happened that they weren't with anymore, you know? So they went and gave testimony to the district attorney's office or to the police.
Sure, but that isn't what appears to have happened. What appears to have happened is that Bell was very much involved as a getaway driver in this incident. He doesn't appear to be someone who's just a hapless Uber driver who finds himself.
he knew these
participating in a
people
crime.
ahead of time. It wasn't a random, drive for hire situation. They knew each other.
Yes.
Okay.
Although he didn't want to admit that at trial, he kept saying that he knew of this person and refused to really say that he knew them, even though McGee Thomas then, and this is where I sort of differ with the prosecution on this point. My point here about McGee Thomas, her testimony here conflicting with the video evidence, she says that there was a meeting beforehand between this group of people, which also conflicts with what Bell said, but that they were discussing Robinson basically as a target for a robbery. But then the video shows Bell arrived with his car at the liquor store first. Then the target arrives and parks behind Bell and then walks into the store. Bell then leaves his car and walks into the store. So the idea, I've described this in my brief as them being improbably lucky, right? It doesn't really, like, how could they have been discussing him as a target beforehand and then have him, this target, just arrive after they're already at the liquor store? That goes against the theory of the crime in the opening statement as well, which was that this was more of like a crime of opportunity, that this guy was noticed at the liquor store, and that's why they followed him to the gas station. That conflicts with what McGee Thomas is saying here, which is that he was the target the entire time.
So
And
I guess I'm going to ask you the same question that we've all asked you. I mean, none of this, we all know all this because it happened in front of the jury. It's part of the transcript. The jury got a chance to evaluate all of this conflicting information or improper motives for their testimony, and we come out with this. But we need to, evaluate the weight of the evidence and the sufficiency of the evidence, and we will do that.
Yes, I think that this case very well could have led to an acquittal were it not for the other errors that are presented in points 2 and 3. The first of which was McGee Thomas's testimony that this wasn't the first time that Mr. Gray had told her that he had shot someone.
Right, so let's talk about this. So didn't the judge give a curative, there was an objection right away, correct? And
there was an objection right away, but the judge's instruction was, I described it as mild, right? He said he didn't hear it. And then he said, well, since it's by consent, disregard it, as though that was the only reason to disregard it, because
that's
they
what
both.
for previous counsels have said about a judge giving a mild almost be mild curative instructions in Erie County.
It was the same judge.
Oh, yeah.
Yes, I think that it's pretty clear that everyone was able to, but the judge was able to hear the comment. There's no indication in the record that, besides the judge not being able to hear it, that anyone wasn't able to hear it. The judge is the person closest to the witness. But that comment was highly prejudicial, right? I tried to make a point of that in the brief with a footnote saying, forget you ever heard about this comment. But once you, I mean, this is a cliche now, but you can't unring the bell, right? You've heard now this accusation that this guy is some maniac, loose cannon. You can't forget it. And the argument here ultimately is that it was just so prejudicial. There's no legitimate strategy to be had by not moving for a mistrial. But the prejudice here is compounded with the process. Oh, go ahead.
If there was a curative instruction, is asking for a mistrial, is that something that is a futile act, considering that the court did give what it considered to be a curative instruction here?
Well, some testimony is too prejudicial for curative instruction to cure.
And you believe that was here?
Yes.
Okay.
That's our, yes. But it's all compounded by the prosecutorial misconduct throughout the trial. I think I identified 6 categories of prosecutorial misconduct, but I'd just like to highlight a few. One that is vouching for the witnesses here, right? So the prosecutor says, we have taken great care to make sure that the evidence that we've presented to you is credible, reliable, and ethically obtained. Well, great. If I'm the jury, I'm saying, well, thank goodness I don't have to worry about any of these problems identified to me before with these 2 witnesses here, upon which the whole case hinges. This is improper. This is misconduct. It's vouching. It's injecting the credibility of the DA's office into the case. And another highlight here is character assassination. Okay, so I tried to make this as clear as I could in the brief, but the focus here is this narrative logic throughout the trial that Mr. Gray is this villainous character who needs to be stopped, right? You jury are the only ones who can do this, as opposed to jury, this is a fact-finding proceeding. Here's the evidence. Find some facts, and we'll take it from there. So it's the difference between fact-finding and this sort of, like, for lack of a better phrase, a witch hunt, right? This is sort of like it's character assassination in the case law and misconduct. Unless the court has any further questions.
No, counsel, thank you.
Morning, Your Honors. May it please the court, Maggie Van Leuven for the people. As we haven't been very brief this morning, I'll try to be a little bit more brief, as I know we have a lot to get to. But I do want to make some salient points that I think are touched in my brief, but just to make them a little bit more clear. Your Honor, what we have here is 4 people in a car. One of them is deceased at the time of trial and grand jury. 2 of them testify. The third is the defendant, right? So when we say we have no eyewitnesses to the incident, what does that really mean? No one person can identify the defendant is the shooter, right? However, with all of this evidence combined, there was an eyewitness that said the shooter got into this car, right? There's no question about that. There's no, nobody said at any given time, the shooter did not get into this car and out of this car, right? So we know it's one of 4 people, right? And we've whittled that down very easily with an abundance of evidence. We have video from the liquor store that shows the 4 individuals in the car. We have Corey Bell, who's undoubtedly the driver. No one said this isn't Corey Bell's car or he drives it. No one said he's not the driver, right? And we've ruled out Corey Bell as the shooter because he's the driver. He is the one that's got the car running. That's like, you know, somebody's throwing the door open in the back. We've got him as the driver.
Here's the getaway driver, according to your point.
Exactly. So how could he be the shooter? He can't be, right? So someone else has to be the shooter. So whatever Corey Bell's motive to tell the story he tell at trial, what does that have to do with whether the defendant is actually the shooter or not, right? Maybe he does want to minimize his activities here, right? So let's just theorize for a moment. What if they all got together, as Miss McGee Thomas says, and says, oh, I want to go get a lick. I know somebody who's got a lot of money. They just came into it, so on and so forth, right? And they're lucky enough to run into the liquor store. The shooting does not occur at the liquor store, importantly. It occurs several blocks away, if anybody knows the topography of Buffalo, at Delavan and Ryder at a gas station, right? Do we think they accidentally showed up at the gas station after they were just at the liquor store? I don't think so, right? The testimony is consistent throughout about the main pieces of information. How they got there, why, okay, there's some differences there. But what doesn't differ is everybody saying the defendant is the shooter. He's the one that robbed this poor victim of his chains and his money in cold blood while this guy was trying to run into the store just pumping his gas on an April day. Why does
Day told them to go park at McDonald's while he ran over there.
Yeah, allegedly, right? But like, do we believe that this person who has a ski mask on April 24th on a sunny day, I believe it was around noon time, do we think that he's up to skiing in April at Delavan and Ryder? It's not logical, right? The people didn't have to prove why this happened. They didn't have to prove the knowledge of the other people in the car or what they did and did not know. Corey Bell had already pleaded guilty at this time. He was dead to rights on being the getaway driver. We knew he was in the car. We have video footage of the car. We knew he was driving, right? What we didn't have to prove was that he knew anything else about the robbery. He's already pleaded guilty. I don't think, as anyone here can expect, that he wants to be a snitch. Is that a good situation for anyone? Probably not. I think
the
that
record reflects that he worried about that.
He absolutely worried about it. Not only at trial was that testimony given, he was given that statement at the very first that he paused when he saw Day or the defendant's actual identification, right? So we've got Corey Bell saying this defendant, how reticent he is or not, he is Day. He's the person in the back of my car. He's the one in the ski mask. They identified him with an O or a zero-shaped tattoo around his neck, dreads on his neck. At trial, there was a discussion about what his body build looked like, and it was the same at that point in time. There was some discussion about the defendant gaining weight later on at trial that matched the person who ran up and shot the victim in this case. With regards to that, anybody can have dreads, right? That's something. Anybody can have a ski mask. Everybody can go get a ski mask. Do we have one on in April? There was a ski mask that was found in the defendant's home and residence at that point of time.
Let me ask you some questions. Okay, counsel for the defense raised a couple of questions that I thought were somewhat important, including the fact that he claims that the prosecutor, improperly bolstered the office of the prosecution and proclaimed their ethicalness with regard to gathering evidence and pointing the finger at this defendant.
Your
What
Honor,
about that, please?
that was in direct response to, I believe, this exact paragraph from the defense counsel. Our justice system is deeply concerned that no person who is innocent of a crime be convicted. How often do we pick up the paper and see through the efforts of some very diligent lawyers, somebody who served 10, 12, 15 years in jail for a crime they did not commit is finally released because it was shown they were convicted on either false testimony, somebody recanted their testimony, they said, no, I testified wrong and this is why, or police misconduct. People are released, not every day, but many times during the year, all over this country because this happens. So the justice system is truly deeply concerned that no person who is innocent of the crime be committed. That is directly attacking not only Corey Bell's testimony, but also everything within the prosecutor and actually the entire justice system, right? We all know mistakes occur. We all know things happen, but this is attacking, this is really prevalent. This happens all the time. Several times a day, we're hearing about people falsely convicted. So he's setting up this thing that says, this is not credible. But not in a way that he's saying, oh, the witnesses are not credible. They're saying the entire justice system is flawed. So that was in direct and fair comment we would suggest with regards to what defense counsel is saying. And that was one of several comments. And I would just want to very briefly, regarding Corey Bell, isn't it troubling, isn't it, that our system does that, allows somebody to plead guilty to a lesser offense than he's charged with, or with lesser offense and indictment? He's been charged with robbery. So he's not just saying, hey, this witness has a bias because he's trying to minimize his conduct. He's saying he's absolutely lying about everything coming out of his mouth because he got a plea deal. And look who allowed him to get that plea deal. And this isn't fair and is not fair to my client. And I would say that that was not fair comment with regards to this trial. And the prosecutor's trying to walk the back and say, wait a minute, the justice system is not all unfair. We're here to get the right answer, whatever that answer may be, and here's the evidence that we're presenting.
What about the claim that the court's curative instruction was weak and ineffectual?
Okay, so I want to go back to that point for one moment. First of all, we're not even sure that the jury did hear that. And the reason I say that is because this attorney, Mr. Terranova, is an extremely experienced attorney. He's done several hundred trials. Everybody knows Mr. Terranova's name, okay? He's done a ton of murder trials. I think the very innocent explanation is he either said, wait, I heard it, she was speaking really softly, but of course I'm intently listening, I'm the attorney. The prosecutor's intently listening, he's the one questioning, right? But the jury, who is a little further away, may not have heard the witness. The judge, yes, who was older, which my co-counsel mentioned, that justice is not known for not hearing either, even at that point in time. So the logical explanation, the strategic explanation here is they may not have heard it. I don't want it repeated. I don't want this to be a point of contention here. And that is a strategic, legitimate reason for not asking for more than what was already given, right? Let's not call attention to this any further. Yes, it was absolutely awful. No, it should not have been said. But even that's why the prosecutor was like, whoa, yeah, well, whatever you want. we'll do whatever you want. We'll agree with whatever you want. And the judge says, okay, I have his exact words because I think there was some confusion about what those were earlier. He's saying here, she says what she says, which we absolutely agree is atrocious. Terranova immediately objects. The ADA immediately says, I would agree. I would agree with an instruction to the jury to disregard that last part. The judge says, I'm sorry, I didn't hear it. You've got to talk clearer. Sentence suspended by consent. Hopefully some of you didn't hear it. If you did, disregard it. And then the ADA goes further and says, Mr. Terranova, if you want an instruction, I would agree with that as well. And Mr. Terranova just says, I think we just got it. The court says, I tried to do it. Disregard that last comment. And please, you've got to talk louder in the mic, please, okay? So I think there's indications by the judge who's sitting next to the witness that it wasn't heard by the jury. So that's one real possibility. We don't know because the jury's not polled, right? But again, there's a strategic, legitimate example of that. And again, the judge regardless makes a curative instruction. And we can't forget at the end of the day too, what the instructions were at the end, that the judge goes through a litany of things about what they should and shouldn't say. If something was told to be disregarded, that you not consider that in your.
I think your stronger argument just it wasn't preserved.
Well, it's absolutely not preserved,
So
but additionally, my co-counsel.
a lot of speculate. You're asking us to speculate. You know, all this. I understand it did say on the record. The judges said, I don't know if I heard you, but you know whether this judge is old, he's hard of hearing. The guy's 35-year. You know, that's all speculation, isn't it?
Yeah, absolutely. I mean, it's speculation.
A lot
It's
to the side case, not speculation.
surely not. Perhaps maybe a 440 would be better apt for this, for that particular reason, that it wasn't heard. It's not on the record as well. I think though that Mark was isolated, there was a lengthy trial, there was many witnesses, there was the prompt instruction from the court, and the trial counsel clearly zealously represented their client. I would say one more thing with regards to that in this particular situation, another strategic analysis would be that even if they did hear it, well, of course, she's spiteful. She's just going to say anything, right? That was his MO in crossing this defendant. Terranova was saying, oh, well, didn't you threaten to kill yourself if he wouldn't get back together with you? I mean, he brought that out, right? So that's another strategic, legitimate reason why they wouldn't. And of course, another, besides the most important part that is not preserved and it's speculative, would be that even a motion for a mistrial would probably not likely have been granted. And of course, we can't Monday morning quarterback a attorney on that basis. Lastly, Your Honor, I would just state that with regards to point 3, the people did not commit prosecutorial misconduct. And the trial counsel's alleged failure to object did not deprive them of effective assistance of counsel. Again, all of those objections are not preserved. They're also without merit. And the people's comments with regards to the defendant being unemployed or greedy went directly to motive to steal and did not amount to misconduct. And with all of the defense counsel's zealous representations of his client, we would say the prosecutor's comments are fair response. If there are no further questions, the people would rest on their papers.
Thank you very much, counsel.
Thank you, Your Honor.
Okay, case number 280. In the matter of Phillips M.
Okay, counsel, can everybody hear us?
Yes.
Okay, do I have 3 yeses? Yes?
Yes.
Okay, very good. Counsel, please proceed.
Your Honor, thank you. Your Honors, may it please the court, on behalf of Mr. Murphy, our case starts and really ends with that there was no personal jurisdiction ever obtained over Mr. Murphy in this petition, the neglect petition against him. Firstly, substitute service was improperly granted by the court. The Department of Social Services made 3 attempts to serve personally Mr. Murphy. The affidavit referenced someone on the street saying Mr. Murphy is no longer here. There were no further attempts under the Family Court Act or the CPLR 3085 for the department to show that they did investigatory searches for him, any checks in his state, he's out of state, any employment requests, any Department of Social Services surveys before they asked for substituted service. Even though then the court, Judge Filbert at Family Court, determined that substituted service would be an option and was appropriate to her, her order was very specific: nail and mail and email. The affidavit of service that the Department of Social Services then presented to the court and as part of the record only shows email. They did not show nail and mail. They had no proof of receipt of sending a letter. They have no affidavit of service saying that nail and mail was done. Even if the Department of Social Services believed he did not live at that residence, there's no proof of that. No mail was returned to the court. It was his address throughout the case. In fact, it's still his address. And they did not properly conform to the rules under case law for email service. The department and the attorney for the child are correct. Email service is allowable. It's not articulated in the CPLR as an alternate service, but there's discretion to the courts, and it's become somewhat commonplace. But because it's not articulated in the CPLR, we need to look to case law. And Snyder versus Alternate Energy states that email service has to be done 2 days in a row and have specific subject lines with the email that follows. The affidavit of service here, again, was only one email, does not have that subject line, and does not have the nail and mail requirements that Judge Filbert articulated all needed to be done, not one. So here, substitute service was first improperly authorized, but once authorized, it was improperly executed, more importantly, and personal jurisdiction therefore was never obtained. Mr. Murphy also never consented to jurisdiction by appearing. At every single appearance, even to this day, he opposes the jurisdiction of the court. He has never participated fully in terms of any asking for any affirmative actions from the court aside from these motions. He's never filed an answer. He's never argued the merits of the case up to this point of this appeal. So no general appearance has occurred. Furthermore, it has to be distinguished. Both the attorney for the child and the department mentioned that Mr. Murphy has conferred his jurisdiction because during the pendency of this action, an order of affiliation was consented to. That is a discrete issue, a limited appearance. There are different standards of jurisdiction. In an Article 5 paternity case, it is where the child is born, where the child resides, or if there's consent. Here he did consent that he's dad, an order of affiliation was ordered. In Article 10, jurisdiction is only conferred by waiver, which he's never done, or by proper service, which we are arguing here was never effectuated. Our second argument lies in that the neglect petition was and is facially insufficient. There was no allegation in the actual petition of actual or imminent harm to the child. While there was no specific acts, no dates, no police report references, no factual allegations that connected Mr. Murphy's conduct to harm or risk to the infant. Sure, it mentions domestic violence, but that was based solely on the mother's statements that were given through a shelter, not even her own statements, with no corroboration. There was no dates or specificity in the petition, and the child was only a month old. While we recognize domestic violence can have an effect on any child of any age, there's nothing here specifically linking those things. Furthermore, and possibly more importantly, the mental health allegations against Mr. Murphy in the petition are vague and unsupported. They speculate that he has an untreated mental health need. No diagnosis, no incidents, no dates, no connection to the child. And under Kelly ECDSS versus Kelly C, which this court heard and which the Court of Appeals upheld, such vague allegations of mental health concerns of a parent regarding an infant are insufficient as a matter of law to confer the possibility of neglect. Based on all of these, we would argue that this petition is facially insufficient. Based on that, as well as the service issues, we are arguing that this petition should be dismissed and the reversal of the order of Judge Filbert of December 23rd of 24 that denied the motion to dismiss the petition be overturned. I do feel I have to raise to the court a more current issue right now.
Counsel, I'm going to interrupt you just for a second to indicate that your time has expired, but I will give you just a few seconds to wrap up.
Sure. I think I've already wrapped up, but I do want to raise to the court. There is this case is continuing in the Erie County Family Court, obviously. There is a UCC JEA hearing pending on May 6th before Judge Filbert. Now, that generally the UCC JEA is not relative to the personal jurisdiction we're talking about here today, but it is relative to the petition itself. And her decisions also could affect some of these decisions. Obviously, your decisions will override any of those in this case, but it is new information that came to light to myself just recently, so I wasn't able to bring that to the court's attention or add to this appeal. But as the court is well aware through the transcripts, Mr. Murphy has raised issues of UCC JEA jurisdiction throughout, which are intertwined with this appeal as well.
Thank you, counsel.
Thank you.
Counsel?
Thank you, and may it please the court, Julie Filion on behalf of the Erie County Department of Social Services. We are asking this court to affirm the family court judgments. We submit that the Erie County Family Court did properly exercise personal jurisdiction over respondent appellant and that the neglect petition was facially sufficient. We would reiterate that we believe that the respondent appellant did abandon his personal jurisdiction argument when he did appear for his paternity petition just last year in July. Should the court not find that persuasive, we submit that he actually submitted to personal jurisdiction through his many appearances in May and June of 2024, where not only did he continually object to jurisdiction, but he appeared with counsel, he appeared virtually, he made substantive arguments, he provided a witness at a remand hearing, he cross-examined witnesses. So we would say that that constitutes submitting to personal jurisdiction. His counsel, it should be noted, is in the assigned counsel program, so he sought the assistance of the New York court system via Erie County. Then thirdly, we would argue that if the court doesn't find that second argument persuasive, that we actually did effectuate service over respondent via substituted service by email, which was directed by the family court judge, which is allowable in the instances when actual personal service would not be practicable. And here, the information that the process server transmitted via the affidavit was that it looked as though this guy was on the run. Someone had informed him that you're not going to find this guy here. He tried 3 times. The affidavit lists 3 different times and days that the personal service was affected. So the law doesn't mandate that you have to keep coming back in the face of information suggesting that someone is dodging service. Significantly, he had a witness testify, his Pennsylvania attorney, that email address was how he communicated with respondent appellant. Notably, he did not ever say that he did not receive the petition and the summons for the neglect proceeding. And his own counsel for the neglect in Erie County said, we were waiting for service. Now that it's been effectuated, we can move on with our objections. So notably, he's never said, I didn't receive it. His appearances suggested that he knew what was going on, and we're not charged with giving with actual service. It's the best service to try to give notice, right? What we're talking about here is due process, notice and an opportunity to be heard. And we maintain that respondent appellant had that via all 3 of these methods. As for the petition itself, as the court knows, all of the allegations are to be given liberal construction, and where we prove up those allegations is at a trial, at a fact-finding proceeding. And here, there were several alleged facts that are so concerning. We maintain that if the child's physical, mental, or emotional condition was not impaired, that it was in imminent danger of being impaired. Keeping all of these unregistered firearms at the bedside table
apologies.
Well, Council Artis,
Yes. May I please,
proceed.
may I please the court? I'm Alicia Artis, for the Department of Social Services in Erie County. We are requesting that this appeal be dismissed, based on, and affirm the findings of the, trial court. If there's no questions from the panel, I can rest on my papers.
Very good. Thank you, Council. Council?
Good morning, Your Honors. Jordan Principali on behalf of the child. I will rest on my papers, but would be happy to provide an update on how the child is doing.
Please.
The child recently celebrated a birthday last month. He turned 6 years old. This child was removed from the care of his parents when he was only 4 months old. So he's been in this placement with a family member since that time. This is the only home he has ever truly known. He enjoys going to school and he's doing very well. He will be completing kindergarten this year and he's starting first grade in the fall. He's incredibly bonded to this family. They continue to provide for all of his needs and he's very happy in this placement. He has expressed he would like this placement to be his forever home. Thank you.
Thank you, Council. Cases 282, 283 in the matter of Dwayne McDuffie Jr. Greenberg, please proceed.
Thank you, Your Honors. I'm representing the mother, Ms. Coleman. Before I begin the central part of my argument, I just want to just give you a brief frame for that argument that this is, of course, is the best interest of the children standard is applicable here, and that the order under appeal is from May 30th, 2024. So as always, as seems to be the issue with family with visitation and custody petitions, we're asking to review facts from 2 years ago. And one fact that has changed since the order went into effect is that the elder of the two children is now over 18 years old. Her birthday was on March 29th, 2008. So we are now past that date. So she's now an adult and that kind of solves half the problem. So she's free to go see Ms. Coleman whenever she wishes.
So that appeal will be dismissed.
Okay, but for the younger of the two children, we would feel our argument would be that that it really was a very extreme giving the father, Mr. McDuffie, sole custody of her. The record does show that my client, did use the corporal punishment, but that was a one singular event. She does go to the mental health. She does go to, I think, specifically Beth Self, where they did not recommend any kind of drug treatment. And she also does visit with the children. So I would ask that you revisit that issue and then either grant her either kind of a joint custody situation or send it back to family court if you wish.
Thank you, Counsel.
You're welcome.
May it please the court. Gary Muldoon for the younger daughter. I'm going to submit on my argument that's contained in the record. I think the record is replete with evidence of the parental difficulty in communicating and best interests, I think, are clearly shown that the children or the younger child should live with the father. What I wanted to do was to use my time to speak as to Michael B. Case to update the court. The child, the mother, I should note, had a neglect finding against her in an order of protection while the case was filed. The child, speaking of the younger daughter, has done much better in school since they began living with the father. The child is attending school in Cheektowaga at Cleveland Hill, is actively involved in the school, and is in junior honor roll. So the child seems to be doing well, is thriving, and so it is my position that the order of family court should be affirmed.
Thank you, Counsel.
Thank you.
Case 284 in the matter of DeLawrence and Frederica. Just gonna wait for Mr. Barney to come online. Counsel, can you hear us?
Yes, I can. Can you hear me, Your Honor?
We can. Counsel, proceed.
Yeah, thank you, Your Honors. And in this matter, I'm representing the father, who is DeLawrence Jr. One of the children is DeLawrence III. My client, just to give you the frame for this appeal, has a very lengthy history with DSS, and that history is very contentious. He said the children were remanded before, he's gotten them back before, and then it keeps going back and forth. In this case, the older daughter, that is really the meat and potatoes of the case, is 17, so she's still a child. Then the accusation was excessive corporal punishment, but excessive corporal punishment always has to be viewed in the context. And in this case, we had an out-of-control teenager who was off partying and getting into scenes that maybe she shouldn't have been getting into. And that was the context of her coming home and being hit. I mean, so that was what instigated the whole current remand into foster care. So we would ask that the court really take a long, hard look as to the child's behavior and in the context. So this is not a case of, coming home with a bad report card and the child is 8 years old and then got hit for that reason. That was the reason we would ask that take a very hard look at those facts, and we would ask that you would reverse it and dismiss the petition. Now, for the second argument, if you don't wish to petition, then certainly find a different foster parent, because the current foster mother is the cousin of DeLawrence Jr., and they don't get along very well. I mean, that too is a contentious relationship. And as I pointed out in my brief, maybe a fresh pair of eyes might not be such a bad idea. Have the children go to a foster house where they, I mean, granted, the counter argument is, well, they'd be strangers, they're not family. But sometimes, you might remove some of the, well, she's my cousin and I'm going to let her get away with this for this, whereas a stranger might take a stronger approach to the children, that they keep them in line, and so they're not running around at night and whatever.
We'll take a look at those arguments, Counsel.
Oh, thank you, Your Honor.
Thank you. Counsel?
Yes, good morning, Your Honors. May it please the court, my name is Richard Barney. I'm appearing on behalf of the Erie County Department of Social Services. I think one thing, obviously, in this case that the department could not deny is that respondent appellant's daughter, who I'll refer to as Child 1, she was exhibiting a lot of troublesome behaviors. That can't be denied. Clearly, there were some issues at school, that she was struggling with grades, and he rests upon that as the basis for engaging in corporal punishment against her. I think what must be viewed also in the record is that this is a child who repeatedly struggled mental health, had been to ECMC following self-harm attempts, had ongoing struggles, had reported to the respondent appellant that she was being bullied at school, and respondent appellant throughout this process was repeatedly dismissive of those mental health struggles. He stated his belief that it was his daughter who was causing the problems at school, despite the fact that there was testimony that she came to him saying she was being bullied. That's truly the context that we're operating in. Clearly, this is a child who had reached out for help. She asserts that she was pulled out of counseling following her most recent mental health issues, which found her at ECMC based upon the respondent's appellant's wishes. He states that the only time that he took her word was when she allegedly told him that she no longer needed to go to counseling. So there's another issue there in that he's not taking some of these concerns very seriously. Turning quickly to the placement, obviously respondent appellant argues against the current placement for both of the children, and again cites just some incidents that are getting back to him through Child 2, respondent appellant's son, that there is some lying going on, that Child 1 is telling lies about Child 2. Again, we can't deny that there have been some additional behavioral issues at the time of the dispositional hearing being shown by the children, but there was adequate testimony that both children were doing significantly better. Child 2, respondent appellant's son, had shown significant improvement in his grades. Child 1, while she was still having some troubles at school, she was attending. She had relinked with mental health. She was showing great strides as well. And the lower court found that the punishment being used by the foster parent was perfectly adequate based upon the situations that were arising. I think that given the trauma that these children have, the things that have happened to them over the course of their lives, it cannot be expected that they would turn a switch immediately once they got to a new foster home. At any rate, it would be, we would submit that it'd be more detrimental to both of these children to upset that foster placement at this point. As this case does proceed, my understanding is that they're both doing well in their placement. They both are very happy there. Both identify it as a safe and loving home for them, and both desire to keep their placement there. For all these reasons, we would ask this court to affirm both the findings of neglect against the respondent appellant, as well as the finding that the continued placement was in the children's best interest.
Thank you, counsel. Case 285, Deming Jr. versus County of Chautauqua. Proceed, counsel.
Good morning, Your Honors. May it please the court. This is a bar exam essay question, if I have ever seen one. What's the standard of review here? Casella made a motion to dismiss pursuant to 3211A7, right? That is the legal philosophy. If that which has been brought without evidence can be dismissed without evidence. That is the motion that we made. And the judge, the lower court judge, made a decision that we hadn't proven our entitlement to summary judgment as a matter of law, but we didn't brief that issue before the lower court. So,
and there would have had to been a conversion, right?
Right.
The judge would have had to put everybody on notice that I'm converting this to a summary judgment motion and proceed along those lines. That was not done here.
It wasn't. Yeah. So we didn't brief that motion. We briefed the motion to dismiss, which should have been granted, in this court, of course, has the authority to do that on this record. There's no allegations in this complaint, the third-party complaint, that would lead to liability on Casella's part. Casella came a little bit late to this party.
Well, you're basing that on your private agreement with the company that you succeeded, correct?
That's correct,
But
Your
the
Honor.
county, was the county on notice of that? Did they accept that, and is that required?
You know, I don't know if they accepted it, and I don't think it's required because the Casella entered into its own contract with the county around the effective time of the purchase agreement with Bestway, who previously had held that work. And that was months after Mr. Deming's accident, months after. So there's no liability under any.
So you're saying that Casella had a subsequent agreement with the county of Chautauqua.
That's correct.
That said that they would not be liable for. Are they liable under that agreement for injuries that happen while their contract's in effect? Your argument is that they're not responsible for the prior one because they weren't a contract.
That's correct.
Party. And the county's saying, no, wait a minute, they just succeeded in this agreement, so, you know, we weren't a party for that.
And that's not accurate, Your Honor, right?
Okay, well, that's your argument.
Yes.
But what about the current agreement? Is the current agreement, is your client responsible for injury? Like if this injury took place while your contract is in place, are they liable?
Yes. Yes, sir, they are. But not under the contract between Bestway and the county, because the purchase agreement between Bestway and Casella expressly took out from any retained liabilities, any acquired liabilities, indemnification obligations that happened from incidents arising prior to the closing date.
Right, and that's between the two parties of that agreement. Why is the county on the hook for that? If there's no notice to them, if they didn't sign off on that.
Because Bestway is still here. Bestway still has the obligations it had to the county. Casella didn't assume those. Bestway retained those. Bestway's here. This lawsuit's going to go on. It's just that Casella is an appropriate party to it.
So just so I understand this correctly, your client took assets, not liabilities.
We took disclosed liabilities, of which there were none.
Okay, so but they were buying. It was pretty much an asset purchase agreement. Is what
It was pretty much, although Bestway did retain some assets.
okay, and there's exceptions to the general rule, right?
That's right, sir.
Yeah, and so if there's an argument to be made that one or two of those exceptions, I think there's 4 exceptions. If one or two of those exceptions apply, then this isn't a motion to dismiss case, because that's the standard we're looking at, right?
You got it. That's
Right.
exactly right.
Yeah.
And there's no factual allegations indicating that any of those exceptions would apply.
So your argument is that there's no factual allegations that there was a merger of seller and purchaser, for example?
That's correct.
And there's no factual allegations that the purchasing corporation was a mere continuation of the seller. And absent, and those are just 2 of the 4, but absent those 2, which are the 2 that I was looking at, you're saying that there's a complete absence of even an allegation of those, and as a result, a motion to dismiss should fail.
Yes, Your Honor. That's
Or motion should succeed.
Should succeed.
Yeah,
Yes.
yeah. You're talking about 3211A7. Okay, very good. I think I have your argument, Counsel.
Thank you. If there's no other questions, I'll just step aside.
Good morning. May it please the court. I'm Kiefer Tian, counsel for the respondent, County of Chautauqua.
Does your opponent have it right? There's no even allegations of the 2 examples that I set forth?
No express allegations to that effect. I will not disagree with that. I think it's applied and alluded to in the allegations set forth that Casella adopted Bestway's allegations, and there was a merger and an acquisition of those 2
So
entities.
if there's even an implied circumstance here, you're saying that it's up to them to carry their burden with respect to the 3211 motion. And because you can possibly read the allegations in such a way to imply that there was a merger, that's enough for you to survive the motion to dismiss.
It's part of it, Your Honor. I think another part of it is that we have adequately pled a cause of action for contractual indemnification that is set forth in great detail in the third-party complaint.
Against Casella?
Against Casella as well as Bestway. We make the argument that at the time of Mr. Deming's unfortunate passing, the contract the contract involving the county was with Bestway. That agreement was binding on all heirs, successors, and assigns of Bestway, such as Casella. Casella then came in, adopted that exact same contract, expressly incorporated all terms by reference in a later agreement dated June 21st, 2021, that does not remove those liabilities mentioned. Those liabilities.
Are you saying that Casella, right? Am I saying that right?
Yep.
Yeah, that Casella, because that agreement that you just referenced was in existence, that Casella had no ability to do an asset purchase agreement, essentially, to avoid liability? That wasn't a possibility, that couldn't happen?
I think that they absolutely could have done an asset purchase agreement, and that is what happened here. But I believe that as a necessary component of that, we have to reconcile the 2 contracts together. The county was on notice, of course, of its contract with Bestway, and that was on notice that this contract was being assigned and assumed by Casella. Once we found that out, the county entered into its own contract with Casella that adopted all aspects of the previous contract between the county and Bestway.
But
Going forward.
This is a 30.
No, going forward.
Yes, going forwards, but it doesn't disclose any of the previous liabilities out there. Those are set forth in the asset purchase agreement, but the county, although on notice of a transaction between Bestway and Casella regarding the asset purchase agreement, we were not on notice of the exact terms of that contract.
Now you still have Bestway in this case.
We do still have Bestway in this case. That's right, Your Honor.
I guess I'm trying to figure out, what do you even want with Casella then? If you have Bestway, and they were around at the time this accident happened, You know, I guess I'm confused as why you even want them hanging around in your case.
And absolutely. And the reason we included Casella, we initially filed a third-party complaint only against Bestway for that exact reason. And then it was kind of made known to us that Bestway was seeming to point the finger at Casella, arguing Casella adopted our liabilities as well, including the liability at issue in this case. And so to cover all bases and be sure the county was adequately protected, we filed an amended third-party complaint against both Bestway and Casella.
Right, but whether that's true or not almost doesn't matter at this point. The key point is you made the allegation that you just referred to, correct? Isn't it your, this is a 3211 motion. So as long as you made that allegation, you should survive 3211 motion to dismiss. Isn't that your argument?
That's exactly right, Your Honor. I think that is our primary argument. And I would also like to point out that because evidentiary material was submitted with the 3211 A7 motion, the standard also converts from whether the county has stated a cause of action to whether the county has a cause of action. I believe both are satisfied here. At the very least, the county adequately pled a cause of action for contractual indemnification. And I believe it also has causes of action for successor liability grounded in the exceptions that Your Honor just discussed with my colleague here. Namely, the de facto merger doctrine is the most prevalent one at issue in this case. We had Bestway and Casella go into an agreement together. On the other side of that agreement, only Casella emerged. Admittedly, it took a few years for Bestway to formally dissolve with the Secretary of State, but it sold all of its intangible property, including IP, its real property, its trucks, its containers, its entire customer list, its accounts receivable. For all intents and purposes, I know my colleague made the point that Bestway did indeed retain some assets. Everything that I've seen indicates that Bestway ceased to exist in everything besides official filing status with the Secretary of State following that asset purchase agreement.
And answer Justice Bannister's question that she posed to you earlier, that that's really the reason you want Casella in here, because they might be judgment proof.
And that's another part of it as well. We believe that Bestway has insurance that might be capable of satisfying some of the, if there is a finding of liability at the end of this case, to satisfy some of that judgment. But in the event it's not, that's another great answer to Justice Bannister's question that, yes, we do want to point to either Bestway or Casella. Frankly, the county doesn't take much of a position on between those two entities who is liable. We believe those can discuss amongst themselves and make those arguments there, but we believe that one of those entities at least is liable on the third-party complaint.
Anything further, counsel?
That's all I have, Your Honor. Thank you very much.
Thank you. Case 286, Calvaneso versus Meckel. Proceed, counsel.
Thank you, Your Honors. May it please the court, Tyler Eckert on behalf of Sean K. Mokel, Paul Fournier Enterprises, Inc., and Modern Disposal Services, Inc. We are asking this court to reverse the trial court's denial of bifurcation and find that the general presumption of bifurcation under Uniform Rule 20242A applies here for three reasons. First, the trial court failed to articulate any rationale for the basis of its decision. Second, neither of the two limited exceptions as outlined by this court's precedent apply in this case. And third, the danger of prejudice to the defendant appellants in this matter is severe given the long list of alleged injuries by the plaintiff, which may engender sympathy by the jury. Speaking to the first point, the order does not articulate any rationale upon which the trial court issues its decision. This court has found a difference between a failure to articulate particular details of a rationale upon which the trial court issues its decision and failure to identify any rationale at all. Here in this case, we don't know why the trial court did what they did. We don't know which exception they thought was applicable, if any, or even if they recognized the general rule of bifurcation as articulated by the court administrator or under CPLR 603. For that reason,
Counsel, let me ask you this, just, I want to understand your argument. The trial court is, as we all know, I mean, this is an abuse of discretion standard. They have abundant discretion to make these kind of decisions. But you're saying that even though there was an argument before the court, which articulated the two sides to why or why not bifurcate this case, and so the court was fully briefed on this and fully understood both sides of the argument, that because the court did not articulate the specific reasons the judge was relying on, that somehow that implicates the court's discretion to make a decision?
Two responses to that, Your Honor. First, I would say obviously this court can exercise its discretion and find that one of the exceptions did apply.
Well, let's stay with us looking at, did this judge abuse its discretion in this ruling?
Sure, I would say that the uniform rules of procedure speak to that, specifically Rule 201.1b, which states that any of these rules can be waived upon a showing of good cause and in the interest of justice. Here, the trial court didn't articulate any rationale, like I said, but certainly not good cause, and they didn't do so in the interest of justice. So we would say that in those circumstances, and certainly where the danger of prejudice is present, that would be an abuse of discretion, regardless of the sufficiency of the underlying papers. But again, moving to the sufficiency of the underlying papers itself, specifically, as I mentioned, there are two limited exceptions that this court has recognized. First,
I'm sorry, just to follow up on our presiding justice question, didn't both sides have a chance to be heard in front of the trial court?
Yes, Your Honor.
And the trial court, at least with what this case law says, we shouldn't disturb that because, unless there's some abuse of discretion, correct?
That's correct, Your Honor, but in order to disturb it, there would have to be a rationale under which the trial court issues its decision. And based on this record, we don't know what that rationale is.
Or are you saying that there's no rationale that would apply? You know, that's what I'm hearing.
It's both, Your Honor. Under the circumstances of this case, there is no rationale under which bifurcation should be denied. But additionally, the record is not clear as to what rationale.
Economy not be appropriate.
Your Honor, judicial economy is a factor that should be considered by the trial court in determining issues of bifurcation. But the question is whether judicial economy is sufficient by itself to overcome the presumption of bifurcation. This court has recognized in Mazur v. Mazur, there are situations where it is, specifically the second limited exception, which is that the liability phase and the damages phase of the trial are both going to be short. Here, plaintiff respondent is alleging that the liability phase of the trial is going to be short. We don't dispute that. We agree that the liabilities phase can be handled in a day, but rather it's the damages phase of this, if it were to be conducted, which would be quite extensive. Not only are there issues of medical causation that need to be determined, there's your medical experts are going to have to testify on all of the various alleged injuries the plaintiff respondent has alleged.
Instead of a 3-day trial on liability, you're talking maybe a 6 or 7 day trial if you add in the medical witnesses.
That's correct, Your Honor.
Okay, but I'm going to transpose that. What about the idea that after a decision is made with regard to the liability, you're probably looking at another year before the plaintiff gets to put their proof on, or maybe 6, 9 months, whatever. It's going to not just be a few extra days. It's going to be months, maybe a year down the road. And my understanding of this case has already been a 6-year delay. Accident happened 6 years ago, and it's still not done.
Two responses to that, Your Honor. First, regarding the extensive delay, 2 years of that delay was due to the plaintiff respondent, who was deposed, indicated they needed to get another surgery, but they were putting it off for their own convenience and work-related issues. And then only 2 years later did they get that surgery, after which we were able to move to this motion. To the second point here, I'm sorry, Your Honor, can you repeat the first part?
You know, that there's, we're talking about a trial that went from maybe 3 days on liability to now double, okay? By the time we have the witnesses, as opposed to a very long delay by the time we regroup, order all those medical witnesses to be present. We're talking 6, 9 months, maybe a year.
Thank you, Your Honor. I think that requires two speculative assumptions, which
Well, listen, I was a trial judge for a long time, and I can tell you, I never did one of these medical cases within a short amount of time. It always takes a long time. Certainly more than the extra 3 or 4 days to put the medical witnesses on now.
let me be clear, Your Honor. I'm not suggesting that it wouldn't be an extensive delay if the damages portion were to be had and it would take a while. What I'm saying is that it requires two assumptions. One, that the defendant appellants are not going to prevail on liability. And two, that after the liability is properly apportioned by that determination in the short trial, that wouldn't lead to a settlement. Here, as in the case with many insurance matters, once liability is apportioned, settlement is much more likely and a resolution of the case can be reached.
And doesn't your expert say that this is not related to it and it's a low impact accident and it's everything's pre-existing? So where's your settlement possibility there?
Your Honor, that's specifically to the medical causation issue. That's a different issue from the actual liability or negligence issue. Here, the liability issue is that Mr. Mokel was positioned in the driveway. There was some exchange of waving each other on, at which point Ms. Calvinesso proceeded. He looked back and forth. He didn't see her. And it's unclear whether, it's clear that she went on the right side of the truck rather than properly entering the driveway on the left side of the truck. She states that's because the truck was turned and she couldn't enter the driveway there. He states he was properly positioned. She went past his truck and then tried to enter on the grass to the right of his truck.
Just to add on to Justice Montour's question, I think he was saying the issues are intertwined. So it would be better fit that it'll be in one trial as opposed to bifurcate.
Your Honor, we disagree that the issues are intertwined, but even if they were, plaintiff respondent has waived that argument. They didn't argue in the initial instance of the trial court that the issues were intertwined to subject them to override the general presumption of bifurcation. So even if there was a possibility of making that argument, it was waived here.
Counselor, does the rule still state that it's supposed to be a bifurcated trial in front of the same jury immediately thereafter? That was always in the court rules. I didn't happen to look at it before this, but is that still the rule?
So it's changed a little bit. Under CPLR 603, it was a much more stringent rule. The chief administrator clarified under the uniform rules that the judges are encouraged to do so. And one of the things that they put in that statute was whether or not bifurcation, if bifurcation would not assist in the simplification and clarification and lead to a more fair and expeditious resolution, that bifurcation is not warranted.
Right, but the rule specifically said that bifurcation shall be in front of the same jury immediately thereafter. And that still says that, right? They never changed that.
That's correct, Your Honor. And in fact,
but is that what you were prepared to do? Or was that, because I know a lot of times in the lower courts, they ignore that part.
Your Honor, I would say that's a decision for the trial court to make in regards to their calendar. However, they feel that could best be done. Our concern here is more to the danger of prejudice that could result from the jury's, engendering the jury's sympathy to the plaintiff respondent. And specifically, the rule 20242A outlines a number of protections on behalf of the party not moving for bifurcation, under which how they can question the jury and other issues there that are not really relevant for this appeal, but are articulated in the rule. Moving on to our final point, again, the danger of prejudice here. There is an extensive list of injuries alleged in this. We have neck injuries, back injuries, bilateral hand and fingers injuries, bilateral shoulders, bilateral hips.
Against the bill of particulars, are you?
I might as well be, Your Honor. It's quite extensive. And again, it's hard to see how that would not engender sympathy from the jury, especially if it was all combined in one trial and all these medical issues were heard about extensively and in detail. And also, I would point this court to the second department's case in Patina v. County of Nassau, in which they considered specifically this, and they said the probative value of such evidence, referring to the nature of the party's dispute, whether it should be weighed against the degree to which the gravity of such injuries will likely engender sympathy for the plaintiff and thereby pose a risk of prejudice to the defendant. The Fourth Department hasn't had the opportunity to speak to this issue yet, whether prejudice itself is enough to find that the general rule of bifurcation should apply and court calendar or, the efficiency of judicial economy should override that concern. And we would ask in the absence of that precedent to look to the Second Department's rationale. And specifically because the trial court failed to consider that as a factor, and there's certainly no evidence in the record that they did so, that in itself would be an abuse of discretion. Unless your honors had any other questions.
No other questions, counsel. Thank you.
Thank you.
May it please the court, Leah Costanzo for the plaintiff. The defendants argue that based on the record that it's not clear how the trial court came to its conclusion, but they're the ones that failed to include in the record the transcript of the oral argument before the judge where there was extensive discussion between counsel and the judge. So I don't think it's fair for the defense to rely on a record that they submitted that was incomplete, where the court cannot consider what the discretion is that the court engaged in denying the bifurcation in this case. But initially too, the Fourth Department case in Fox that we cite, bifurcation is improper if the nature of the injury bears importantly on the issue of liability, or it wouldn't assist in clarifying or simplifying issues and provide a fair and expeditious resolution of the case. Defendant's brief argues in number one that a low speed impact cannot cause the injuries that plaintiff sustained. So their own brief attempts to argue that they may submit some medical evidence in the bifurcation trial because they want to establish that this low impact accident cannot cause her injuries, which is supported by their own doctor.
So is that intertwined?
Yes, Your Honor. And even so, the other improper reason for a bifurcation is the fact that it wouldn't assist in clarifying the issues and expediting the trial. In this case, defendants are defending not only on liability, but also on injuries. They don't believe any injuries are related. So I think liability is more complicated than defendants want to indicate. I don't see an instance in this particular matter where a jury decides, the possibility or the large possibility that both parties are at fault or that the defendant is at fault, which leaves the defendant in the case for a liability trial where the defense is now going to argue that the plaintiff didn't sustain any injuries from the accident, guaranteeing a second trial. We are 6 years into this litigation and 8 years past the time of the accident. Obviously, plaintiff disagrees with the fact that she was the reason for the delay. There was extensive COVID. She was scheduled for the second surgery. She was the night before there was a second bout of COVID. It was canceled and then it needed to be rescheduled. But regardless, it doesn't matter. There's of the facts that are presented in front of this court, there's no indication that this could be more expeditious in resolving this case from what's been presented. So I think for that reason, the court was in its proper discretion to control its calendar and judicial economy and indicate that it wouldn't be appropriate in this matter.
Anything further?
Nothing further, Your Honor. Thank you.
Thank you, counsel. Case 287 in the matter of Janet Hess. Proceed, counsel.
Morning, Your Honors. I believe it's still morning for a couple more minutes. My name is Amanda Lau. I represent Barrett Hess, and we appreciate the ability to be here today to discuss what we believe was an erroneous decision by the surrogate judge who afforded full faith and credit to a Florida court decision after we raised issues regarding due process under the Florida court decision. As we've laid out in our papers and we advised.
Was there a judgment of divorce in Florida?
There was, yes.
And your client was a party to that judgment of divorce?
He was, yes.
The judgment of divorce, the order emanating from that indicated that that emanated from that judgment of divorce indicated that he appeared and was heard on that proceeding, correct?
The language of the order reflects that. There's an affidavit from my.
The order says he was there.
Yes, the order
Right?
does say that.
There was no motion to modify the order, change the order, to correct the order.
At that time, no, there was not.
Right. And action was taken by your client pursuant to that divorce happening relative to property distribution, including a transfer of title to the house in Florida?
Your Honor, so there was a deed that was
Did-
filed about
Did
4
a
months
deed
after.
change after the divorce that put the title fully in his name?
The court order, if it is valid, as the respondents say it is, it would transfer automatically under that judgment of divorce.
Okay. And so that title transferred after the order was in place.
Correct.
He became the sole owner of the house in Florida.
That would be if we are still arguing that that
The order
is void.
The
because
order was signed and filed,
It was.
right? It wasn't vacated, it wasn't changed. By operation of law, he became the title owner to that house in Florida. You're agreeing to that?
I am agreeing that under the respondent's argument that it is valid, that yes, he gets to be the owner of that home. However, in terms of their arguments on the briefs, it's a reliance or collateral estoppel argument, right? That he should be collaterally stopped from attacking that judgment. We submitted in our papers that we don't believe collateral estoppel should apply as a void order is void is void is void. It doesn't become less void because of the moral character of the party that you're attacking.
Your client got a divorce, acted under the terms of that divorce, and you now want the divorce to not be considered a divorce. He wants to go from being a divorced man, the marriage over, to having the divorce not be in effect or have any gravity. And then he gets to become the heir to the now deceased ex-wife's estate. That's the plan here, right?
That is the argument that's been raised by the respondents. It is-
Let me ask you this, when the petition was filed, he was petition for probate, he filed it, right?
Correct.
Okay. In that petition, was there any reference at all to him being, that there being an order of divorce in Florida in effect?
I don't recall that, Your Honor.
You don't recall it?
I do not.
Continue.
Thank you, Your Honor. As we've raised in our briefs, we believe that the Florida court law applies and that the surrogate should have reviewed under Florida court law and statutes whether the due process rights were.
Why should the court have done that? Nobody raised that issue.
Mr. Hess did raise that issue,
Okay,
Your Honor.
but not anywhere near the time of the alleged divorce. Only after her death. He raises that issue,
He
but
did raise the issue in Florida before her death. I believe that's in his affidavit, that his motion to vacate that judgment was withdrawn without his consent.
He was counseled to withdraw that affidavit because he could get into trouble if he continued pressing that.
Which, as he understood, he didn't understand what that would mean, and he still did not consent to it.
He was an attorney, right?
Yes.
A New York State attorney.
He is a retired. Yes.
Yeah, but I mean, he practiced law.
He did, yes.
Yeah. Okay. Anything further?
Your Honor, we just respectfully submit that the surrogate should have reviewed under Florida court. We've provided Florida court decisions about what due process means, including receiving notice of hearing, and that we've created an issue of fact about whether that occurred.
We'll take a look.
Isn't he arguing that his wife, he's arguing the wife's lack of standing, because he's arguing that she didn't receive notice, the notice that he sent to Chautauqua with an understanding that she doesn't get her mail anyway, so she probably won't get that, and she probably won't have notice, and I can get a default.
Well, Your Honor, that the point about who can raise the issue of notice under Florida court, there's nothing statutorily or case law saying that it has to be one person or the other when it comes to a void judgment. The judgment is void, it's void, it's void. It doesn't become valid against one party because they received notice and the other party didn't.
yeah, so people default all the time and judgments still get taken.
Understood, Your Honor. And I think that's the distinction here between how New York functions and how Florida does. Because as we put out in our paper, the third prong is whether there's certain due process requirements that are met. And that's why we cite to Lemoyne, we cite to Spector.
Those are
Richel.
due process rights.
I'm sorry?
Those are the decedent ex-wife's due process rights.
Again, Your Honor, that's what we've raised in our brief in terms of the circular argument. The respondents argue that Barry can't argue the divorce decree is void because he's not the executor, so he's not standing in her shoes. But at the same point, they're arguing that Barry is not the executor because the decree is valid, right? And I would also just submit one additional item. At the time the surrogate made this decision in this case, there was no one standing in Janet's shoes.
Well, and again, when you're saying waiving her rights as far as notice of this, not having notice, she brought this divorce proceeding, right?
She did, and there's no doubt here at the beginning that there was jurisdiction, but in Florida, that's not the end of the end of the analysis. It continues on.
Well, it seems like the court made all the appropriate analysis when they indicated that the husband was there, he testified, and there was an equitable distribution. To each party got $2.8 million worth of assets. It appears as though now it looks as though he's trying to lay claim now to her $2.8 million as well.
Your Honor, I understand that there is an argument by the respondents that this is all about money, right? I get that argument.
Maybe.
However, I would point out to the facts that he's put in his declaration that would undermine that, right? So after this,
So he doesn't want the money.
I'm sorry,
He doesn't want the money.
to him, it's not about the money. I mean, a
It's about
person.
his wife's due process rights being violated.
A person who is all about the money would not have rented her properties, paid for her travel, paid for her cultural events. All of this is in the record, arranged for her dog walkers, maid services, paid for issues in the house, paid for a private charter, paid for her doctor's bill, health insurance. That's not someone that's all about her money. That's someone who was treating someone as their spouse.
Anything further, Counsel?
No, Your Honor.
Thank you.
Good morning, Your Honors. May it please the court. Michael Zoller of Hodgson Russ on behalf of respondent Jennifer Hess. The question in this case is whether a New York court should undo a final Florida divorce judgment at the behest of the very spouse who sought it, who participated in it, who relied on it, and is now repudiating it. A party who receives a notice of a Florida hearing cannot challenge a judgment arising from that hearing based on an alleged notice defect to his adversary. Here, appellant asked this court to make new law so he can attack the Florida divorce decree he obtained on the basis that his ex-wife Janet did not receive proper notice of the hearing. Appellant asked this court to adopt this novel theory without citing a single case on point, i.e. a case where a party who received notice of a hearing and obtained a judgment subsequently attacks the very judgment they obtained on the basis that their adversary did not have proper notice. The court should affirm the decision below that the Florida divorce decree is valid and entitled full faith and credit because it is undisputed that appellant had proper notice of the divorce proceeding. The court actually need go no further and can affirm on that basis alone. There are three other arguments we have: judicial estoppel, equitable estoppel, and the fact that appellant.
So those arguments are in your papers?
They are, yes. And one point actually going to what Your Honor raised before as far as the deed. So first, the actual divorce judgment transfers the marital home to Mr. Hess, the appellant. But actually, it's even worse than that, Your Honor, because subsequent to that order being entered, Mr. Hess executed a deed transferring that same marital home from himself to his revocable trust. He signed that deed in his capacity as a single man. So years after this divorce decree was entered, he affirmed in a document that he filed with the Florida clerk that his divorce was valid, that he was a single man, and that he took the marital home. So the standard here is that a sister state judgment is presumed to be valid and will be given full force and effect unless the opposing party can meet the heavy burden of showing the absence of jurisdiction. Again, appellant can't meet their burden here. Appellant petitioned the court in Florida. Appellant received notice of the hearing. Appellant testified during the hearing. The court relied on the appellant's testimony in valuing the real property that it assigned to him. And then appellant effectuated that the division of marital property. Again, he did so not only by taking the marital house as part of the judgment, he then transferred it to his own revocable trust.
And you represent the children of the marriage.
What'd you say?
You represent the children of the.
I represent the daughter. There are so there are three children in the marriage. I represent Jennifer Hess. There are two brothers. They do join in this in our argument today. I'll go through again every single case cited by appellant: Spector versus Uber, Reisel v. Gregg, Polani v. Payne, Lemoyne Group LLC versus Edgewater South Beach Condominium, Toulouse v. City of Fort Lauderdale, Rodriguez v. LS Commercial Funding LLC, Watson versus Watson, Lee v. Lee. Every single one of those cases involves a party who did not receive notice of a hearing, challenging the judgment based on an alleged notice defect to them. In not one of those cases did the party argue, oh, the judgment is invalid because my adversary didn't receive notice.
No, we're aware of that argument. Counsel, is anything further?
The only other thing I'll say, Your Honor, I'll skip to, I guess, our very, very last point, which is, even if he could raise the argument based on Janet's based on the fact that Janet allegedly didn't receive notice, they actually did not establish here or raise a tribal issue of fact on that point for two reasons. First, here, the judgment itself says that notice was mailed to Janet. One of the cases, they cite Spector v. Uber. In that case, a notice of a hearing was mailed to a party's counsel. That party's counsel then withdrew. That party's counsel did not forward the notice to the litigant. The Florida court nevertheless held that, well, mail service is okay in Florida. It withstands constitutional muster. We mailed service to your counsel. That's good even if you did not receive actual notice. Here, their argument fully relies on actual notice. They say, oh, well, Janet didn't go down to the mailbox to retrieve her mail. Well, even if that were true, and again, they don't even raise a tribal effect that it is true. But even if that were true, it's irrelevant. Proper service was achieved by the mailing. Also, the very last point is their argument on that Janet did not receive notice is based on one, the affirmation of appellant, which is self-serving and says upon information and belief she didn't go down to get the mail. The fact that it actually says upon information and belief, as a matter of law, that does not raise a tribal issue of fact. There's a case, I believe it's Wood v. Norse, from this department that stands for that proposition. And then lastly, they rely on the affidavit of a caretaker, Douglas Rashbrook. Rashbrook says he didn't get the mail for Ms. Hess, and that he was not aware of any other caretakers getting the mail from Ms. Hess. Again, that's just pure speculation that nobody else did or that she never went outside his presence. So for all those reasons, the Surrogate's Court got right and the judgment should be affirmed.
Thank you, counsel.
Thank you.
Case 288, Whitfield versus Waterloo Central School District.
He's on the ticket. Video. Sorry.
Counsel, can you hear us?
Yes, Your Honor, thank you.
And we can hear you. Counsel, please proceed.
Good morning, or maybe afternoon, Your Honors, and may it please the court. My name is Ken Lowe of Cantor Wolf McCastro and Hall. I'm here appearing on behalf of the claimant appellant. Given the submission of the respondent in this case, I think it's important not to lose sight of what we believe is the simple fact that the law implicated in this case is very much in favor of claimant's position. We believe that the court below ignored relevant case law and abused its discretion in conclusorily denying claimant's motion. I think it's very telling that respondent's entire preliminary statement is dedicated to a public policy argument. The law is not on their side. It's an exercise in distraction and misdirection, not to mention the public policy argument is misguided. There's no question that the infant in this case is troubled, but the public policy focus here, if any, should be on the systemic bullying that, despite respondents' knowledge thereof, went unchecked and unaddressed by respondents, despite the reports. Respondents' position attempts to absolve them of responsibility and complicity in the persistent bullying that pushed a client to extreme and unfortunate ideation.
Counsel, let me bother you for a second.
Sure,
Okay,
please.
count, the infant plaintiff is still under the age of majority, so their statute of limitation is not expired.
That's correct, Your Honor.
And then your other argument is that the school district had chapter and verse about knowledge of what went on here, okay? And you showed that by some of the our prior lawsuit, okay, that we handled here, the prior appeal. And you showed that there were DASA complaints and the mother's testimony that she called both the village and the school district office, okay? So I think you covered in your application both ends of the requirements here, that there's still time left on the statute of limitation and that the school district, had all of the pertinent facts here. Okay.
Oh, I mean, thank you, Your Honor. I think I'm inclined to agree with you.
All right. All right. If there's anything else.
If Your Honor is indicating that you would not like me to.
Don't assume any indication.
I was just summing up because I thought you were missing the one thing that you spent a lot of time in your brief with.
Sure.
Which is what they knew about the incidences that gave rise to you wishing to put in a late notice of claim.
No, thank you, Your Honor. I appreciate you bringing that up. No, I was about to get to the more pertinent points, I think. But like I said, respondents dedicated so much of their papers and the first maybe 5 pages of it to these public policy arguments that I thought, rather than regurgitating the points that I'd laid out in my papers, I would address those. But I mean, that being said, I do think general municipal law is very much in favor of us. I think that the case law indicates that the courts are to construe the criteria liberally, and I don't think that the court below did that at all, as stated. I think it's very conclusory and fails to address any of the law that we cited. And I think it's important, among all the things, again, Your Honor mentioned, the actual notice element. I think that's clearly laid out in the papers. The reasonable excuse, I think, speaks for itself, that she was dealing with these criminal proceedings and her child being taken out of her custody for a significant period of time. And as for the prejudice, there are essentially 3 important steps here that happened. There was the bullying itself, which was reported. There was an investigation in the criminal matters. And then after that, there was also the July 2024 notice of claim that we served without leave in order to try to further stem any potential prejudice. And so I think that more than meets the standard that's been laid out in the common law, in as much as sorry, I lost my train of thought, but the burden shifts is the bottom line, is that once we have put up a plausible argument that there is no prejudice, the burden shifts to the other side. And the respondents responded with absolutely nothing, not a single document to support their position that they were prejudiced, just pure speculation. And unless there are any further questions, I will rest on that.
No further questions, Counsel. Thank you.
Thank you.
Counsel, proceed.
Good morning, Your Honors. James Special for Waterloo. A couple points that I want to mention is, first, on the prejudice point. I don't believe that plaintiff ever met their burden on that one, because and the trial court actually pointed this out, that for this case to proceed, we're going to have to rely on memories of very young children. They don't really put anything forth that clearly points out that the relevant people, even claimant, her son, remember this clearly. And this kind of reminds me of the point of the case we just heard that we were just listening to, where they just say, oh yeah, we think that everyone will remember all of these facts. And I don't believe that the trial court's decision is conclusory at all. For instance, one thing that the trial court says is that he says it wasn't lost on him that they tried to file a notice of claim in 2024. Then there's a gap until April 29th of 25 when they finally make the motion. And given that we're looking at an abuse of discretion standard here, I mean, is there enough to say that the judge abused his discretion? And if you look at it, I don't think it's conclusory at all. I think it's laid out very logically in fact, and the judge backs it up and explains his reasoning. So I definitely wouldn't say it's conclusory at all. And for that reason, given that it is an abuse of discretion standard, I don't think there's enough to say it was an abuse of discretion.
Thank you, counsel. Any further?
Nope. Unless there are questions from anybody.
No questions.
All right. Thank you.
Thank you.
Thank you.
Case 289, Village of Allegheny versus City of Olean. Okay, very good. I believe we have both counsel on the screen. Can you hear us, counsel?
I can, Your Honor.
Okay, very good. And Mr. Spitzer, would you undo your mic so we know we can hear you?
Yes, Your Honor, I can hear you and hopefully you can hear me.
We can, just for when the time comes. Very good. Counsel, proceed.
Good afternoon, Your Honors. If it may please the court, Charles Grieco, Bonchenik and King for the Village of Allegheny. Our position here, we believe, is fairly straightforward. As I believe Your Honors are aware, this is a case that is a dispute over some intermunicipal sewer arrangements and some charges between the city and the village. And in this case, by way of counterclaim, the City of Olean asserted a number of counterclaims long after it had served a notice of claim in 2022 that was very clearly, quite explicitly, based on a breach of contract theory. It was seeking damages of about $1.1 million for certain defined costs that it alleged the village owed because of a intermunicipal agreement between the city and the village. It also sought declaratory relief for the court to declare the parties' rights and obligations under that agreement. The notice of claim could not be more clear on that point, and that is the only relief, the only claims that were included in that notice of claim were a breach of contract claim and declaratory judgment claim for declaration of the parties' rights under that agreement. However, when the city served its answer to the village's Article 78 and declaratory judgment action, seeking to require the city to negotiate an agreement and to abide by the terms of the agreement, the city asserted counterclaims that not only were not based on that contract, but explicitly sought to repudiate that contract. Their first cause of action was to declare that the contract did not exist. It had expired. And it then sought to—
Counselor, by promoting those or advocating for those counterclaims, contrary to the notice of claim, which apparently just alleged a breach of contract, your claim is that this is a violation of CPLR 9802?
That's correct, Your Honor. And we think that that is clear from the language of 9802 and a uniform body of case law interpreting 9802. 9802, unlike some other notice of claim requirements that are found throughout New York statutes, is very clear that a notice of claim is required not only for contract actions, but any other action. No other action shall be commenced against a village without a notice of claim. And the courts have interpreted that to that no other language permits of no exception. So therefore, courts have applied that or have held that notices of claim are required in the context of seeking equitable relief, declaratory relief, extra contractual relief or non-contractual relief like quantum merit, as the city's one of the city's counterclaims is in this case. There is no scenario, there's no claim essentially that you can assert against a village that does not require a
What about the fact, as far as the notice is situation, as far as the purpose of the notice of claim? I believe that the city's gonna argue that they sent all these letters to you, there was invoices that were sent to you, so you absolutely had notice of these contentions that we're making that you should then be responsible for these particular payments.
Well, so again, we think the case law is perfectly clear, and it comes from the Court of Appeals that has made this point, as well as several appellate divisions, that the notice of claim requirements are strictly construed and that they apply regardless of whether the village or the municipality has actual notice of the claim. The case law is also clear that you cannot, mere correspondence between parties cannot substitute for that strict compliance requirement for a notice of claim. And with regard to that correspondence, I would also point out that the village was very clear that it never agreed with the city's assertion that it now claimed it could unilaterally charge rates that were not set forth in an agreement between the parties. So and we don't believe the city cites any case law whatsoever to support the notion that merely because the mayor at one point sent a letter said, you know what, we're no longer operating under this agreement. We are now going to charge you in a different way that we've determined. And then and when the village responded to that saying, we completely disagree with that, the village, frankly, the city was obligated at that point, if it believed, if that was its new theory and its new claims, it was obligated to file a notice of claim, and it didn't do that. It simply asserted counterclaims without the benefit of a notice claim that are based on completely different theories and frankly different costs.
There were no efforts to amend that notice of claim?
Well, as the city pointed out in the reply brief, I believe, or maybe it was in their initial brief, they have subsequently filed a notice of claim, but that's not before the record on this court.
Right.
And we can argue when we go back below as to what the effect of that notice of claim was, but no, there was no attempt to amend their notice of claim. But importantly, on that issue, if you look at their notice of claim that they did file in 2022, they did seek to reserve the right to amend it, but it was specifically to say that the city reserves its right to amend its statement of damages as necessary to properly reflect the monetary loss it has incurred as a result of the village's breach of contract.
Right. Still the reference
that it was going to.
Still that reference to the breach of the contract. So
absolutely, everything in their notice of claim is completely premised on a contract that they now seek to repudiate.
Anything else, Council?
I would just quickly address the exceptions that the city seeks to rely on. And that is, well, first of all, at one point they allege that 9802 only applies to contract actions. That's just clearly wrong as a matter of law. But then they seek to do that it shouldn't apply here for basically two reasons. One is that the village should be estopped. And they cite a number of cases where estoppel has been applied in the notice of claim context. But the case law is uniform in saying that estoppel is a narrow exception that is only applied where the party who failed to file the notice of claim was induced to not file that notice of claim and justifiably relied on either the negligent or intentional miscommunication, misdirection, misconduct on part of the party. this record is completely devoid of anything that could suggest that the village induced the city not to file a notice of claim once the city decided it was pursuing a different theory of recovery. And we think that the case law is very clear on that. The other exception that they seek to rely on is the public interest exception. And again, we think that simply does not apply in this scenario. The cases that, we cite in our brief to cases that involve disputes just like this between municipalities where the courts found that the public interest exception did not apply. That's the Muttontown case and the Macedon case. They cite to a number of cases that have held that a notice of claim is not required under very unique circumstances. And that is where somebody is claiming to vindicate an important right, not for itself, but for all similarly situated class of the public. And the resolution will directly affect the rights of that group. And if you look at the cases that they rely on, the Cayuga case, the Rampello case, the Yagan case, those are all very, very different situations here where the courts found there were specific issues there that applied, that where requiring a notice of claim was going to frustrate a different part of the statutory scheme, or were frankly just facial constitutional challenges that weren't based on facts. This is a fact-specific dispute here between these parties. So we don't think the public interest exception has any applicability here. And I apologize if I already mentioned this, but just on the last argument that I want to address, if I didn't, was the notion that somehow communications between the parties can satisfy a notice of claim requirement. As we point out, the courts have recognized in Filson and the 110 case and the Ippolito case that is not a substitute for a notice of claim requirement, simply because the parties shared some correspondence. And in this case in particular, what the correspondence shows is the city was arguing to the village what its position was, and the village consistently said, we disagree with that. The cases where sometimes the courts have been a little more liberal on the notice of claim requirement is that there's an acknowledgement on the part of the village or the party who was required to have a notice of claim served upon it, which again is really similar to the estoppel situation where the actions of that party have given the party that's required to serve the notice of claim some reason, justifiable reliance not to do so. Those facts simply are not present in this case. And with that,
I think we have your argument, counsel. Thank you. Counsel, proceed.
Thank you, Your Honor. Daniel Spitzer on behalf of the city. May I respectfully suggest that, and particularly going to the issue of the amendment, the city was put the village on proper notice from the beginning of this very long dispute that goes well back before 2020. And the notice of claim, while it covers part of what's in front of you and why the judge properly refused to dismiss these counterclaims, it also is important to note that the city, in fact, did amend with the August and December letters, which are in the record, and the village responded to the August letter, contrary to that. That's in the record. So first, let's talk about the first counterclaim. They said, oh, you can't raise a declaratory judgment about contract rights under a notice of claim about contract rights. Let me respectfully note to the court that there's an affirmative defense in front of the lower court, that the contract expires. They have not moved to get rid of that affirmative defense. In other words, the court still has to decide, is this contract in place? If the contract's in place, then all of the counterclaims are properly in the notice of claim, with the exception of number 6. I'll get to that separately with regard to the environmental conservation law. If in fact they are correct, then the money they owe us under the August letter, under the December, all the bills, is calculated under the contract. And the notice of claim goes specifically to their failure to pay those amounts. They keep forgetting that they haven't paid the amounts under that contract. Part of this case arose because the city residents have been subsidizing the village residents because of they simply chose a number, 300 grand out of the air, that they were going to pay. They weren't going to rely on the city budget. They argued about what's in the city budget. They breached the contract. In addition, the contract terminated by law. There is an affirmative defense that first declaratory judgment action is still going to be before the court. It's certainly, I would respectfully argue, what a claim that discusses the rights of a party under a contract certainly includes whether that contract is expired. As to the other two letters that very clearly laid out, let us first note that paragraph 24 of the contract that they want to keep in place says that the village will continue to follow the code. In other words, the city code governs this. Their causes of action related to the fees are under the city code. Yet they want to say that a separate cause of action wasn't included in that August letter. The August letter says this is a formal notice. It qualifies completely on its own under 50E, excuse me, as a notice of claim. It was sent to the right party. It was served on their council. It includes bills that explain how the city came to the amounts due. It explains what the law was that was applied. And you have nothing in front of you, and Judge Parker had nothing in front of him that says that that notice of claim of August was not sufficient under 9802. As we point out, as you pointed out in the, I'm probably pronouncing this wrong, the Bettet versus County of Monroe case, you can have amendments of notices of claims as long as they arise from the same facts. So you can't bring a counterclaim that says, by the way, the village truck ran into a city car, you owe us money for that. But you can have, when you have breaches that lead to ongoing debt requirements and ongoing payments, you most certainly can have updated bills. You most certainly can have additional comments. And if you look at that August letter, you look at that December letter, which they are stopped from denying they had for the very reasons my good colleague, Mr. Grieco, said, because they responded to the August letter and acknowledged it. They disagreed, of course. And there's certainly factual disputes to be determined below and legal disputes.
So it's your contention that the village had notice of all these factors.
A notice in spades.
And they're related to your notice of claim. Is that right?
They're related to our notice of claim. And obviously, in terms of events that we're applying to after the notice of claim, in terms of the debt, we reserve the right to update the debt, update it. They were still paying under the contract. We were saying the contract didn't apply. I think those goes right to the very term of the notice of claim. What are your rights under this contract? They claim we still have a right only to be charged under this contract. And now they're saying to you, oh, but it's not a notice of claim related to whether or not we have to be charged under this contract. I think they're trying to have it both ways. And we really ought to get this back on all 6 of these back to the court below to determine the factual issues. If the contract expired, what was due, what was fair, did the contract expire, we think is obvious, but it's not before this court. I would also note on the 6th cause of action, there's no requirement for a notice of claims on environmental conservation law. That's a separate item. It has nothing to do with contract or equity. You're not allowed to violate state law. We are the enforcement agency. We have a right to bring a claim, and they have violated multiple times. We brought it in this court rather than filing a complaint with the DEC. We thought that was appropriate. But there is no question, and they certainly don't deny, Your Honors, that they had full notice of everything. They're simply trying to say a hyper technicality. Yes, we had notice. Yes, we knew you from the affirmative defenses and from your letters that called themselves formal notices that you believe they expired. Yes, we had noticed that you applied this code. You had every single thing under 50E in writing, but somehow we didn't have notice of claim. Judge Parker should be affirmed. We would respectfully ask that the 2nd and 6th causes of action, counterclaims be restored. Other than that, I will stop ranting and happily answer any questions.
Thank you, counsel. Case 290, Bush versus County of Erie et al.
Good afternoon, Your Honors.
Counsel, proceed.
Jeremy Toth, I'm filling in for Eric Marriott, and I will be very brief. It's essentially our contention that when a federal judge, after several years of litigation, makes a ruling on a summary judgment motion, it is not an opportunity to kind of get a do-over or start over. You still have to plead a cause of action. You still have to abide by statute of limitations. you still have to have a notice of claim if that's appropriate. And so for those reasons, we're asking this court to overturn the lower court's denial of our motion to dismiss.
Thank you,
All right,
counsel.
great.
Unlike you, Mr. Doug, unlike.
Counsel, proceed.
Hi, Your Honor, Blake Sacanino on behalf of the plaintiff here. Judge, I'll be brief as well because I know it was a long brief. Our basic argument is that the Judge Reese in federal court dismissed the claims, the state law claims without prejudice with the right for us to refile. We feel that we had made all of the claims that we put into our new complaints in state court that we refiled in our federal court complaint, specifically on the failure to maintain the premises. We expressly put that in our amended complaint, which is what Judge Reese ruled on. We feel that we've cited many cases that discuss the obligation of the jail to maintain a safe sanitary environment, to provide proper food to these inmates.
But isn't the question whether it's litigated in federal court, not whether he gave the right to refile, it's whether the actual facts were litigated?
Yes, Your Honor. And my response on that would be that Judge Reese did not rule on any of our state law claims. She ruled on our civil rights 1983 claims. And I think we cited some case law in our papers where the judge specifically held that a person could be, or a county government entity could be negligent, but still not found to be liable under a 1983 claim. So that's our basic argument, is that the judge declined to exercise supplemental jurisdiction over our state law claims and didn't hear him.
And since we're being brief, you don't dispute that you're not entitled to punitive damages or attorney's fees, right?
Yes, I would just say on that issue, I was speaking to the claim of punitive damages against the individual defendants. And I know that we did cite to one case in the record that talked about how punitive damages against government entities is not per se unavailable. So we just wanted to make that argument as well.
Very good. Thank you.
Thank you so much. We appreciate it. Thank you.
Case 291, Bashada versus Ahmed, MD.
Name's up.
Proceed, counsel.
May-
We have everybody here, right? Yep. Okay, very good.
May it please the court. My name is Lauren Heimer. I'm here on behalf of Dr. Hamed and Suburban Rheumatology, which is her practice. The motion before the lower court was a summary judgment motion, both from plaintiff side and from the defendant side, and Judge Panapinto denied all motions. So the first question before this court is whether there was an abuse of discretion. We believe that there was not with respect to plaintiff's motion for summary judgment. We believe that they did not meet their burden on causation in particular. And then in response, Dr. Hamed did her own affidavit along with the affidavit of Dr. Karmoudi, who is a orthopedic surgeon. So we covered both deviation and causation, whereby plaintiff did not. And we know that plaintiff acknowledged almost these deficiencies in their moving papers by submitting a second affidavit from the same doctor, Dr. Chatpar, that he did on the first motion as in opposition to our motion, and then put in the affidavit of a retired surgeon named Dr. Hickson, who both of those affidavits can only be considered in opposition to our motion, not as initial moving papers. And then the second component there is that Dr. Hickson was not qualified to render any opinion on this oncologic surgical case. So if we take one step back on the facts, it's that Dr. Hamed was treating this woman for a well-known medical condition called seronegative rheumatoid arthritis. She treated that patient in two separate chunks. The first chunk would be the December 2014 up until April 2016. The patient then left her care And then she returned in 2018, where the subject MRI was read by the co-defendant, not by my client. So it's really important to look at this from Dr. Hamed's perspective to say it had to be deviation from the standard of care within her scope of practice, and that her deviation caused injury to this patient. And so we've proven in our papers, and why we think we're entitled to summary judgment where plaintiff is not, that Dr. Hamed.
Didn't Chatpar opine that Ahmed misdiagnosed the seronegative arthritis?
So the argument was that seronegative rheumatoid arthritis was a clinical condition that was diagnosed. And he said that Dr. Hamed failed to make that diagnosis because he, Dr. Chatpar, did not actually look at all the medical records. He ignored all of the bilateral symptoms, the systemic symptoms, the ultrasound, and a X-ray that all happened before April of 2016 to support the diagnosis. So he can say all he wants that if you ignore certain facts, sure. If I ignore the fact that the totality of the circumstances are supportive of rheumatoid arthritis, then the diagnosis was wrong. And even Dr. Hamed said at her deposition that she still believes this patient has rheumatoid arthritis, the seronegative rheumatoid arthritis. It's just that when she ordered the MRI that was done in July 2018, Dr. Hamed gets assurances that there's no cancer. So she continues to treat the patient for the symptoms and the clinical signs that are consistent with the underlying diagnosis of seronegative. And I think the more important issue here is that it's whether or not the treatment would have been different had that diagnosis of cancer been made in July of 2018. That's where Dr. Carmody comes in, and she explains why an amputation was always going to be necessary for this patient as of July 2018. So Dr. Hamed says, yeah, there was no indication for an MRI before 2018, and here's all the reasons why. And when there was an indication for an MRI, here's what I did. I ordered it. I got assurances that it's not cancer. The language of the report says this is not cancer. So she says, great, I'm going to continue to treat you the way that I've been treating you. And then it wasn't until 2021 where symptoms changed again that triggered the need for the repeat MRI. And I think that's all clear in our papers. And that's why Dr. Hamed is entitled to summary judgment on these particular issues. Plaintiff didn't meet their burden on causation. We then met our burden. In response, we get Dr. Hickson, who's attempting to talk about causation, but he's not qualified to do so. And unless your honors have any other questions, I will rest on my paper.
No other questions. Thank you, counsel.
Thank you.
Counsel?
Thank you. Good afternoon, your honors. Many of our arguments are pretty similar, so I think I'm going to be very brief. I represent Dr. Snitzer. He's a radiologist, and a lot of our papers highlighted the distinction of the fact that his duties to the plaintiff were extremely limited. That was completely ignored by the plaintiff in their papers, both in support of summary judgment as well as in opposition. So
the extent of his duties.
His duties were to review the MRI, make interpretations, and document his findings. And that is what he did. That was what his duty was. Any talk about biopsies, recommending biopsies or care that was subsequent to his MRI, that is beyond his duty.
Whose duty then was it? I mean, once his report is filed and it's sent to Dr. Ahmed, right? Once that happens, if there is a need for a biopsy, whose responsibility is it to indicate that?
That is the treating physician who's managing the care. So in this case, it's Dr. Ahmed.
So he had no direct communication with the patient, correct? So it would have had to have been in his report if you were to make that recommendation.
Oh, yes, absolutely. This goes to his limited role. He sees nothing but an MRI and the requisition for that study. He doesn't have any medical records. He doesn't know the history of this patient. He has no conversations with the patient where she's describing her symptoms and how long she has suffered
So his role is very limited, his duty is very limited, he does his job, he takes a look at the films and he interprets them, does a report, sends it off. At that point, he's on to his next film.
That's correct.
Okay.
That is consistent with the law. That's consistent with what he did here. The other issue with regard to so we said that basically that there's no duty. Dr. Snitzer was entitled to summary judgment. We also in our papers, we addressed the issue of proximate cause. And that's what co-defendants counsel highlighted was Dr. Carmody's affidavit. It was detailed, it was factual. She's an orthopedic surgical oncologist. She deals with these type of cancers that Mrs. Rashada had. And she indicates that as of the date of Dr. Snitzer's involvement in Mrs. Rashada's care, that she was going to need an amputation. The location of where the mass was, its proximity to nerves, bones, ligaments, this all would have affected hand.
The amputation was gonna happen whether there was cancer or not?
If it had been cancer, it had a biopsy been done, we're saying, even if you got to the point where you said negligence, we're going to address that issue. There's that second prong of proximate cause. And basically, okay, how did this negligence affect her future care? And what in our position, and based on Dr. Carmody's detailed affidavit, is that she was going to need amputation one way or another. That was just the proximity of this tumor being in the hand.
And that's, in your argument, is at the time that Dr. Snitzer did his reading, did his report, and sent it off, according to the expert, at that point in time, whether there was a biopsy or not, if there was a biopsy, it was going to reveal cancer, and that was the condition of the hand, and there was going to be no way to avoid the amputation.
Yeah, that's correct. That's my argument, but it's based upon the expert's conclusion. So that essentially is why we believe Dr. Snitzer is entitled to summary judgment, and that all due respect to the trial court, that they were incorrect in finding an issue of fact.
So it doesn't matter if he misdiagnosed that 2018.
We don't concede that fact.
No, but my question, it doesn't matter.
It would not have mattered. The amputation was the only treatment that was viable. One, to get at the tumor, but also to ensure that it had not spread. And in the affidavit, we talk about that. Fortunately, this is a case where it did not spread. But that was certainly a concern that the doctors who were addressing the tumor would have had. So once the biopsy was done, had the cancer been diagnosed in 2018, there's two concerns. One, hand function. Can we get that tumor out and save some function at hand? But also, can we, for lack of a better word, keep the genie in the bottle here and make sure that this hasn't metastasized or spread outside the hand? Fortunately, that wasn't the case here, but that would have been the thought process that those who would be treating the cancer would have.
So, and again, I think there was some discussions by Dr. Snitzer and maybe in his deposition concerning confirmation bias. He thought maybe, well, he's getting this question or an interpretation in his mind already that it's just the seronegative arthritis.
Yeah, there was.
So he's like, oh, that's what I see. It doesn't appear to be cancer. But you're saying, regardless of that, it was going to be an amputation in 18 or later on in 21.
Correct. And really, I think there's been some misrepresentations about that line of questioning. It was presented in a way from the plaintiff of Monday Morning Quarterback. And if you really look at how he answered that, he was asked if it was confirmation bias, and he agreed, just with the benefit of now knowing,
Right.
he had issued a report. And with Monday Morning Quarterback and benefit of hindsight and a retrospective analysis of knowing that there was a biopsy done and that was a cancerous mass, he was just more or less explaining how it could have happened. So that's essentially our arguments with regard to why we believe Dr. Snitzer is entitled to summary judgment. I can address why the plaintiff didn't meet their burden. I talked about the duty aspect that wasn't addressed at all by the plaintiff in their moving papers. They addressed negligence. They didn't talk about proximate cause, and they only did that in opposition, the court has heard, in opposition to our summary judgment. And they tried to say that, oh, this is my affidavit from Dr. Hickson, and I'm going to address proximate cause in opposition to defendant's motion, but also in further support of the plaintiff's motion. We cited the law that you can't do that. It's statutory and there's case law. It's too late to try and cure a deficiency in your moving papers with an expert affidavit in reply. We also take the position, similar to our co-defendant, that Dr. Hickson doesn't have the qualifications even to render that opinion. And we take the position the court correctly, if it was the reason why they denied the plaintiff's summary judgment, was because Dr. Hickson does not have the qualifications to render opinion as to proximate cause. They attached his CV as part of his affidavit, and you can see that this is a doctor who was retired in 2015. So for him to comment on care that happened years afterwards would not be appropriate. It also was he's a.
Let me just understand that argument. You're saying that if somebody retires from practice as a doctor, that the minute they retire, they're no longer qualified as an expert? Or are you saying the 15 years gap by operation of law, we should deem them as unqualified to act as an expert?
I think it's a consideration in of itself. Would that be enough?
It goes to weight?
Well, no. The weight of the evaluation of the expert's qualifications is where I'm going to, and it is not weight. In of itself, I believe that is a reason why the court could elect to disregard the qualifications. But here it goes even further. This doctor is not treating this type of cancer. They were very careful, I think, in their affidavit to try and suggest that he deals with hand cancers. That's pretty broad. And they cut it very thick in saying that, and I think it was deliberate, because when you look at the CV of the doctor, you see he's a plastic surgeon. And I don't mean that to discredit, that's an important job, but if you're going to submit an affidavit in this case, that's a key distinction. This is a cancer case, and you got a plastic surgeon who's retired, who doesn't set forth in his affidavit any training with regard to cancer patients that didn't occur in 1984 when he did a brief fellowship at Roswell Park, and he's treating cancers of the head and the upper extremities. It doesn't say he's treating the hand. And so, although to answer your question in a long way, is that it's not just that he's retired. It's really more, our point more goes to his lack of qualifications to render a meaningful opinion in this case, in opposition to Dr. Snitzer's motion for summary judgment. But to kind of circle back, you really don't get to the proximate cause argument because of the duty argument that we also raised.
Thank you, counsel.
Thank you.
No, we're not done. We're gonna give Mr. Hayes a chance.
Good morning, afternoon. Any lines of questioning you'd like to throw at me before we get?
Proceed with your argument, counsel.
Okay. On the duty and the proximate cause, because that's where we just spent some time. The duty, among other things, is to read the X-ray or the MRI report correctly. Okay, all the cases they cited were, if the report is read correctly, then you don't have to recommend a biopsy, and people don't necessarily have to, they can rely on your report. Here, he read the report, he read the MRI incorrectly. So he violated that duty in the first instance to read it correctly. Question of fact as to whether he has a duty to order a biopsy or recommend a biopsy. We've got our expert Hickson says, yes, he does. Well, I think our radiologist says he has the duty. Their expert says, no, it's the primaries.
Counsel, let me ask a question about
Yeah.
that. Is the duty to recommend to the treating, who he's sending the report to, recommend that a biopsy be done? Or is his duty to actually order the biopsy? And is there any importance in that distinction?
My understanding is that the cases hold that there is a duty to communicate the need for or the recommendation for a biopsy. I don't know that he has the authority to order a biopsy. So that's your duty, but he read the thing wrong in the first instance, so he's negligent as I see it.
So you're saying that on the MRI of the hand, there was evidence of cancer there?
There was evidence, yeah, that was the very large pannus formation in the hand. That was almost the size of your palm. That was there. Everyone agrees, I'm sorry.
What if that's the wrong test? Like, we're talking about, should he ask for another test, but with a mass there, is the right test a biopsy?
That's the only one that anyone has suggested would be the definitive test to determine if that mass was cancerous or a pannus formation or something else. Nobody said that you can do anything else. So that's what everybody says. That was the need in the next step. So,
So in the first instance, he misdiagnosed, is
Right.
your argument.
So that's
And
negligence.
had he diagnosed properly, he would have sent a report out that indicated that biopsy was necessary. Not that he was ordering one, but that he was saying in the report, a biopsy is necessary. That goes to the treating. The treating, of course, can receive that report and make his or her own judgment.
That is correct.
Can look at the report and say, well, I disagree, and I'm not going to order a biopsy in this case, or I will. Right?
And that would get him off the hook, which is exactly what happened on the second MRI. The radiologist, same Winsong group, looked at it and says, this looks like cancer to me. A biopsy is recommended. And the doctor takes it, and that's when we make that further step.
What about the argument that we've all heard just now, that it didn't make a difference, proximate cause?
Right.
Regretfully for this, your client, the die had been cast.
By
It had been
2018, yes.
By 2018,
Bring that.
when the first, so I want you to answer that if you would. That report goes in, whether there's negligence or not, the fact of the matter is the same result occurs.
Two responses. One, our expert Hickson says, question of fact, I think that if it had been diagnosed in 2018 as opposed to 21, that remedial measures could have been attempted and we might have been able to sustain some hand usage, etc.
Amputation was not a fait accompli.
No, he said 30% chance, I believe it was, which is substantial, 30% chance of recovery. So that's your fait accompli thing. That I think there's a question of fact there. All right, regarding that aspect of damages.
What about qualifications of your expert?
Well,
you heard the challenge to the qualification.
Right. He's got cancer experience. I think it goes to weight, but he's got cancer experience. He's still board certified. He's still licensed by the state of New York. That means he's taken his CMEs. He's up to date. To just say to someone that simply because you're old, and I can attest to that, that your credibility and veracity are suddenly out the window. I think it goes to weight. But even if you throw them out entirely, even if the trial judge were to do that, they're all overlooking the fact that if you had done what they said you should do, then she wouldn't have had the hand. She wouldn't have had 3 years of swelling of the hand, loss of use of the hand, pain in the hand. She had growth of the tumor in the hand causing problems. Those are damages, regardless of when ultimately you lose the hand. So those are damages. And then and this is replete in all the medical records and in Ahmed's records, that she had these complaints from 2014 on. So she had pain in the hand, swelling, loss of use, et cetera, damages, proximate cause due to this not being diagnosed sooner. So I think that it's that he was negligent for not reading the MRI correctly, and I think that there are proximate cause. As to Ahmed, and this was sort of raised by you all, everybody agrees, looking at the records, looking at the x-rays, looking at everything, that the plaintiff had cancer when she went to Ahmed back in 2014. She had cancer of the hand. That was the cause of the complaints in the hand. And if what had happened as happened to the orthopedic surgeon, she went to an orthopedic surgeon first, and he said, you don't have carpal tunnel, so I don't know what you got, but need to see someone else. So he recommended EMG. She goes to an EMT specialist or EMG specialist. He does an EMG. He said, no, there's nothing wrong with your the electrical movements. You need to someone else. Maybe you should try a rheumatologist. So she goes to Ahmed, who says, I think you have this disease that we cannot prove. We have no evidence of it. For 7 years, we have no evidence of it. I'm making a clinical description and diagnosis, and I'm going to treat you for 7 years, when in point of fact, we know, everybody knows, there's no dispute. Their experts agree, our expert agrees. The problems in her left hand were caused by the cancer starting in 2014 and before. That's what her problem was. This woman treated her for the wrong disease. And I just point you to it. I'm not going to belabor it because I know you'd never do it. But the charge
Could be the first time.
that a doctor has to have the requisite knowledge and skill to practice their profession and what they're doing. And that goes to Pike, and that goes to the Carpenter case, which I think is good law, but it's going to be one of those stealth cases. Nobody will ever mention it, and no lawyer's going to dig it up for another 20 years. But that holds that if a physician practices outside their specialty and tries to treat something that they don't know anything about, and their client admits, I know nothing about cancer, I know nothing about x-rays and radiology, but I'm going to treat this woman for her left hand. And she misses the diagnosis, she gives the wrong treatment, and in point of fact, we don't even know that she has this seronegative arthritis. I think that that Carpenter applies, it should be absolute liability. I'll take negligence. I think that's fine. But and there was just one other very brief thing. I just give me 1 second, if I may. Sir. Oh. We all talk about, all of us, our profession is resting upon the concept that there must be, in these negligence cases, solid evidence, objective proof in support of our claims. You hold it to plaintiffs all the time. And the entire defense is based on a disease that has no objective proof. There's absolutely zero objective proof, evidence of a scientific basis in the record that suggests that she has seronegative arthritis. It is by definition a disease that you cannot touch, feel, or see. It's intuitive. It's clinical. Well, if I was to bring a plaintiff up here and said, well, I have a clinical problem, you guys could laugh me out of court. Okay? For a defendant and a physician to get away with that and say, well, they may have this mythical disease. And that's my excuse for 7 years for not diagnosing cancer of the hand. I think the standards are stronger than that, and I ask you to enforce it. Thank you.
Thank you, Council.
see she did that, I noticed that.